Good morning, everybody. It's Super Friday. Welcome to the Courtroom Files Live. If you haven't been following along this week, Wednesdays was the new Fridays and Thursdays is the new Wednesdays, which we've decided we're pretty sure makes this Super Friday now. So let's have a great day. We're going to start in Lenawee County, Michigan. Judge Anna Marie Anzalone, I believe she's doing her sentencing docket this morning.
Your Honor,
give you an opportunity.
Prior to that, can you tell me what the allegation is of the actual violation of probation?
Yeah. Hold on. Wait, I gotta get his file. Some players. All right, I'm sorry, Miss Adams, you did not get the violation of probation paperwork.
No, I think Frances is looking at her emails and is going to forward it to me because I don't see anything scanned.
Okay, so is it the March 17 of 25 violation or no?
I only saw that one. I didn't see anything on the other two files.
Okay, so Miss Underwood, Miss Clark is looking that up for you right now. So just bear with us for a minute. And when we get that, we will.
Because I have a recommendation. I have an updated recommendation, and Mr. McCarron provided me with a police report from August 17th. And is that when we're talking about a violation from?
Judge, Miss Clark only had the recommendation as well.
Okay, so we're gonna have to find that. So I'm gonna have to call down to Mr. McCarron to get that. Then, correct? Someone?
Or is this an old violation?
Is he on all files, Judge?
Yeah, I've got it for all three files.
Okay.
But I don't see that he pled to, yeah, he pled to larceny, 200 to 1,000. So it looks like he pled to domestic violence. He pled to
Why? What's the other one?
must have pled to misdemeanors and everything. So we'll get a hold of Mr. McCarron here this morning. So you guys just bear with us. All right, Mr. Malaro, have you now had a chance to review that letter?
Yes, I have.
And have you had a chance to review the letter?
Yes.
Okay, good. All right, so all right, and Mr. Evans, I don't even remember if I asked you now because I moved on to other things, but you've had a chance to read the pre-sentence report?
Yes, sir.
And you've had a chance to discuss it and review it with your attorney?
Yes.
Are you satisfied with Mr. Malaro as your attorney and the advice that he's given you?
Yes, sir.
Mr. Malaro, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
No, Your Honor.
Mr. McCready, do you wish to explain or challenge the accuracy or relevancy of any information?
I do not.
Okay. Does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect? Mr. McCready?
No.
Mr. Malaro?
That's my knowledge.
The probation officer has computed the minimum sentence and guidelines to be 0 to 6 months. Mr. McCready, do you agree with that calculation? And Mr. Malaro?
No objection.
Okay. Before the court passes sentence, it's my understanding that we have someone who wishes to speak. So, Mr. McCready.
It's 0 to 7, sir.
So ma'am, step up to the podium and you can pull the microphone down, okay? And make sure you address me. Okay, and just look at me and speak loudly. So take a deep breath, and when you're ready, you can proceed. Okay, what is your name?
My name is Zora Evans, Your Honor.
Thank you. All right, you may proceed.
Your Honor, I'm thankful for the opportunity to express how this whole situation has deeply impacted every part of my life and even my career. As you know, while I was still pregnant, he was arrested for a DUI and had my car impounded. After that, I didn't let him use my vehicle, but he kept asking, and every time I would say no, he treated me with complete disrespect, showing no regard for my emotional well-being. There were multiple incidents where he became intoxicated and verbally aggressive, even in the presence of my mother. I ended up filing a police report after one of those episodes got out of hand. His anger often escalated to yelling, cursing, and slamming doors, frequently in front of my family and heartbreakingly in front of our children. One of the most devastating moments was when I confirmed that he had been using cocaine. So many times when I asked him if there were any reason he would have so many bleeding noses, he would yell at me, telling me I was unbelievable for asking things like that, instead of being concerned for his well-being. So many times he dismissed me and made me feel like I was crazy and dramatic. And then I was later informed by my command that I had tested positive for cocaine, a substance I did not knowingly ingest. His actions jeopardized my career and left me feeling violated, confused, and scared. Every time he repeatedly crossed boundaries, calling and messaging me nonstop, breaking into my home and threatening to take our son, I felt less and less safe. He even used the ashes of our miscarried child as leverage, saying he had taken them the day he left, trying to manipulate me into letting him come to the house to return them, but refusing to give them to a family member to have them brought to me. It's difficult to put the emotional and mental pain of this into words. He went so far as to email my mother multiple times, trying to manipulate her and make her feel guilty for protecting myself, saying I was wrong and I was hurting the children. His brother even took the time to reach out and tell me that I'm going to rot in hell for what I am doing to his brother, further isolating and intimidating me. Because of all this, I have had to start therapy and am now on medication for depression and vivid nightmares. I live in a state of hypervigilance. I can't go to the grocery store without having to scan the parking lot for fear that his car might be there. And every minute I'm inside the store feels like hours, and all I can think is when I turn the corner, he's going to be there. I had to install security cameras around my home just to feel safe and some sense of safety. On top of this emotional turmoil, I've had to navigate work investigations directly tied to his behavior, all while grieving the loss of our child and trying to maintain stability for myself and my children. Your Honor, I respectfully ask that the no contact order remain in place for the entirety of this duration. And I also ask that the remains of our child be returned to me so I may grieve and honor that loss of dignity and peace. And this is not about anger or revenge. This is just about safety and the ability to move forward in life. Thank you.
Thank you very much. Mr. McCready, anything you'd like to say on behalf of the people?
Yes, very briefly. So we agreed to a plea to aggravated stalking here. One of the reasons was that it allowed us to have 5 years probation. And we've agreed to 1 year in jail suspended. And the primary reason for that is so that the defendant has no contact with Ms. Evans. That we need something held over his head, and I would just want the court and the defendant on notice that if there is any contact, directly or indirectly, we'll be back here in a heartbeat asking for a jail sentence. I understand a child in common. I understand they were married, I understand their emotional involvements, but it's been her choice and she's entitled to make. But she doesn't want any contact with him from here on out. And she's done everything she's supposed to do in terms of getting a PPO, letting the court know when he's violated it, up to the point of then when he committed this offense, breaking into her home in the middle of the night while she's away on duty, active military duty. So I just want to be on the record and clear that there's to be no contact as the court is going to sentence him. So thank you.
Thank you. Mr. Malaro, anything you'd like to say on behalf of your client?
Yes, Judge. I think the underlying tone here is substance abuse. I think that's clearly a factor here. And Mr. Evans was the one that got involved in it. And I think underneath that was, as Ms. Evans alluded to, is the loss of a child, and people grieve differently. And a lot of people turn to substance abuse to mask that pain. Mr. Evans, because that I think is slowly realizing not only the damage that that has caused, they didn't deal with this grief in a more appropriate manner, not only to himself, but to others, including someone at some point in time. These two people loved each other. It's evolved into where we are now. Mr. Evans has managed to, as the court has alluded to, honor the terms of his bond by staying away from the seven. They have a child. I believe they have a child together. So that's going to have to be resolved in the domestic relations case and all the things that go along with that. And as the court knows, those are always very emotional components to it. Mr. Evans understands very clearly that he is on a tight leash here. Any violation is going to get him a year in jail. Now he has a very good employment, and I'm sure he does not want to have that one stable part of his life to get flushed down the drain. We did reach this agreement, and it's clear that Ms. Evans has suffered from his actions. He will have to spend a considerable part of his life trying to make amends for that. I know that he gets confused about his actions with respect to his desire and love to be with his children. Hopefully he can see that how he treats the mother of his children is a direct reflection as his role as a parent to those children. I think that's the point of Veterans Court here, Judge. It will help him come to that realization to be a better person, a better father to his children, regardless of his relationship with his children's mother. The only matter we would ask the court to permit with respect to a term of probation is he has children from a prior marriage that live in Louisiana, and he has a parenting plan with them. And I'd ask the court to allow him to travel out of state for the purposes of that. So with that said, Judge, I'd ask the court to follow the recommendation as submitted. Thank you.
Mr. McCready, for purposes of parenting time with his other children, the people have no objection to allowing travel for parenting time purposes to Louisiana.
As long as he is in compliance with the terms of his probation here, that's fine.
Okay, thank you. So, Mr. Evans, is there anything you'd like to say on your own behalf? And you're going to need to make sure you speak loudly because we do record these proceedings.
I didn't mean for any of this to happen, but I miss my family, I miss my kids, I miss my wife. When I went home, I just wanted to see my kids, and I just laid in bed with them. And this is the last time I even heard her voice, was at night. And it was the last time I was happy. I came to talk to him, see him. I never meant to or hurt anybody. That was my best friend. And now I've been moved from my home. I haven't seen my children, and I love her at the same time, all at once. I go to counseling. It's helping, but it's. I didn't mean to hurt her. I miss my kids. I'm sorry. Anything that I've done upset her.
Judge, I might add, Mr. Evans has engaged with a family law lawyer I've spoken to, so I think some of the issues that Ms. Evans has requested can be dealt with in family law setting.
Okay. So I'm looking, we have a PPO show cause that has been adjourned over with this. I'm looking because I can't remember if anything was filed to end the PPO. And I don't think it was, but the bond conditions do remain in place, and the PPO actually expires on today. So the PPO expires today, and I'm not seeing where it was extended. But do you understand that a PPO violation carries 93 days in jail, right?
Yes.
This offense you're going to be on probation for carries prison.
Yes.
So it's far more effective than the PPO. Do you understand that? And the pre-sentence report at the time it was done said there was no active personal protection order. There was, but it expires today. So I don't know. Oh, Mr. Jones, just so you know that. Anything else?
Nothing.
Mr. McCready?
Nothing, guys.
So, in determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication for the law, and the protection of society. This case will be transferred at the conclusion of today's case to Judge Olsaver for purposes of the Veterans Court Program. You will be placed on probation for a period of 5 years. There is a 1-year jail term that is being suspended pending any violation of probation. That's not really a good deal for you. They're doing that to hold that over your head, because if you violate, you're immediately going to do a year in jail, and we're still going to have the term of probation.
Yes.
Okay. You are to pay $750 in court costs, $130 crime victim rights fee, $68 in state costs, $60 DNA fee. There is a $30 per month supervision fee and $60 if we have to put another tether in. So I know you're wearing a GPS tether today, correct?
Yes.
And I believe that gets removed as of today
No objection at the cross.
because you're being sentenced, but understand that if there is one violation, we're going to put that right back on you. And one of my favorite things of the week is when the probation officers go follow people and make sure where they've gone, and they watch you, so they know. Your jail is suspended. You will enter and complete the Veterans Court as part of the sentence. During your term of probation, you're not to violate any criminal laws of any unit of government. You cannot leave the state without consent of the court other than to travel to Louisiana for purposes of parenting time. But you can't go anywhere else.
Yes.
Okay. And you must not use or possess alcoholic beverages or any other intoxicants. You must not enter bars or other places where the primary purpose is to serve alcohol for drinking on site. unless you've been given written permission for employment, but I don't want you working anywhere they serve alcohol. So if you go to Jerry's Pub for dinner, that means you gotta leave Jerry's Pub when the dinner service is gone, because then it's the primary purpose for drinking alcohol. You must comply with the requirements of drug testing. You must take all medication as prescribed. Not if, like, some people like to take extra to get high or whatever, you can't do that. You understand? You must test as required for that, as well as alcohol. Can't use or possess any illegal controlled substances or drug paraphernalia, and that does include marijuana, unless prescribed by a physician, or be with anybody who has them. Must truthfully report to the probation department as required. And did you do the domestic violence program with Sally? Okay, so I am going to order that program, Mr. Coast. Miss Sally Welsh. Whose is this? Is it, or I'm sorry, Mr. Jones.
Yeah,
This is yours, right? Yeah, so we'll order that long-term domestic violence program with Sally Welsh.
Yep.
And then, okay, and then you must submit to search of your person and property, and that includes your car, your phone, your residence, wherever you might be, your computer, without need of a warrant if the field agent has reasonable cause to believe you have items that violate the conditions of your probation. The probation department can enter your residence anytime for purposes of verifying your residence and so forth. You must report any arrest or police contact, loss of employment, or change of residence to the field agent within 24 hours. So Mr. Evans, you know, I do believe in redemption. I believe you have a host of mental health issues, as well as substance abuse issues. You know, I believe that's something you can do, but it doesn't happen overnight. You know, you may never regain her trust, and that's the price you will pay. Do you understand that? But that doesn't mean you can't become a better person or by dealing with these issues and get back to the important things in your life as well. But understand it's not going to happen overnight. Okay. Now, all right. So we have ashes of a child. Okay. And it is your child as well. So what I'm going to ask is that those ashes be returned when you report to the probation department. Ma'am, you're going to need to divide those ashes so that he can have half and you can have half, okay? I don't know how, I mean, I have ashes, I got my dad's ashes, I have other ashes, but I believe if you take them somewhere, they would be able to divide them so that he can also have some of the ashes, unless you guys had a plan to bury them. I don't know what the plan was. So.
Yeah, I don't want to mess with it.
Okay, so, all right, can you bring them when you report to the probation department? And then the probation department can notify me, and then we'll notify Mr. McCready, and the victim advocate will contact her to get those returned, okay? There is nothing worse than a loss of a child. My parents lost an infant, and it impacted their marriage, you know, their happiness and everything else. So I hope that you're in counseling to deal with that loss, as well as these incidents occurred in you as well. All right. So he's going to, when you report to the probation department, you'll bring them in, and the probation department will let us know, and we'll make sure we facilitate getting it to the victim advocate to return. And then you will obey and comply with any other provisions in your articles of probation. Do you understand that?
Yes.
You have to get in control of your behavior. That's been the biggest issue here.
Yes.
Okay? Now, you do have a right to appeal this sentence, and my bailiff's going to hand down to your notice of right to appellate review. You're going to sign one copy for our file to acknowledge you received the paperwork. The other copies are for you. If you wish to appeal your sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days. And Mr. McCready, the PPO has expired as of today. There have been no further violations. Is it all right if I just dismiss the show cause on that?
Yes, although I may have missed it, but I didn't hear your honor say, enforce the no contact provision of the plea.
Oh, there's a no contact.
It's direct or indirect with her military.
Yeah, and I was like wondering, like, okay, where do you grocery shop?
Myers, you should be.
Okay, all right. And then, do you ever go to Marshall's, Michael's, Ross? Okay. So, because I don't want you to get in trouble for having contact, and I don't want her, so do you shop anywhere else? Okay, and so if you can just limit in Lenawee County, your grocery shopping at Meyer, and ma'am, that would free you up to shop other places. All right, obviously out of county, you can go wherever you want, right? So, but all right, we'll add that as a term as well. All right, Mr. Jones, do you want him to report Tuesday morning at what time?
Well, Judge, he's actually going to go to Miss Teskey's caseload, and she's in the office today. I think she'll be expecting him to come over there, so he can just report today. But I was going to say, obviously, the ashes probably wouldn't be taken care of today, so he can just note that for the next report when she gives them.
Okay, all right. So when you're done here, you're going to go out the hallway and step over to the probation department, check in, and sit down. All right.
One last thing, Judge. One last thing. So that Louisiana travel, is that a regular occurrence? Was that just a one-time deal, or how is that? I just want to get clarification.
I have a court order. Every spring break, summer, every other holiday.
All right, so you're going to need to get a copy of that order to the probation officer. And so it's a couple times a year for parenting purposes. And if he's doing well on probation, I have no problem with that.
Okay, can we just make sure that's on the judgment so we can have that on the terms, and then there's just no confusion if we get
so Ms. Adams will add that he is able to travel to Louisiana for purposes of parenting time.
Thanks, Judge.
Okay. All right, so I'm going to have you step across the hall, and then we're all set. Thank you.
Judge, if I may, or just so I have a complete understanding, he's only to shop at Meyer for groceries?
In Lenawee County.
Right, but only Meyer for groceries.
Yep, so because he said that's the only place he goes.
Okay.
So, all right, and I think that won't impede him, and that'll ease her mind a little bit too.
Understand.
Okay, all right, very good. So go to the probation department. Thank you.
All right, good morning, everybody. Happy Super Friday. Once again, welcome to the Courtroom Files Live. Michael says it's a heavy start to the day. He's right. Austin said that Judge Mercer had something heavy this morning. Well, guess what, Austin? That's who I have queued up next. So we're going to go to the Judge Mercer, and we'll see if we encounter what Austin's talking about.
Counts of lewd and lascivious battery, a person over 12 but less than 16 years old, and one count of lewd and lascivious molestation within the same range, over 12 but less than 16. Your mother, your father, and a couple of other friends or family members are in the courtroom. Miss Jordan is also in the courtroom. I want to tell you, I have read the complaint, Mr. Tadlock. There is probable cause in the complaint. I think I'm the judge that read it initially and issued the warrant. In addition to that, on your criminal history, there's a reference to a prior similar charge, a sex offense, that is. And so I went back and read the most of the file in the Washington County case, so I'm somewhat familiar with that. This morning, Ms. Jeffco with the State Attorney's Office has advised me and the defense that she has filed a motion for pretrial detention. That's been filed, and I've also been advised that Ms. Taggart, it's not Ms. Taggart, Ms. Jordan now, right? Ms. Jordan would like to be heard. So Ms. Jordan, if you don't mind, if you'll come on up, ma'am, I'd be glad to listen to anything that you want to make sure we're aware of. Right here so he can see and hear you too, please. Thank you. Yes, ma'am.
Good morning, Your Honor. My name is Michelle Blankenship Jordan. I'm an attorney practicing here in Jackson County as well as across the Panhandle. But today I'm not here in my capacity as a member of the Florida Bar. I'm here today in my capacity as the mother of the second known victim of the predator that sits before you today, Tyler Jerome Tadlock. Tyler was introduced to our family by my cousin Mandy when he was 4 years old, and we welcomed him into the family with open arms. Tyler spent many days at my home as a child. My children loved him as a cousin. We celebrated when his dad and my cousin were finally married. But in the fall of 2018, Tyler would do something that would forever change the lives of everyone in our family, but particularly the life of my then 8-year-old daughter. It was the afternoon of an early release day in October. Because my son and Tyler were in the same grade at school, and Tyler's dad and stepmom both worked in another city, we offered to pick Tyler up from school and let him stay at our house until they got off work. At the time, I was operating my law office from home, and I had a house full of adults. The entire third floor of my home was my children's playroom. On that third floor, you could find my daughter's play kitchen, washer and dryer, high chairs, baby bottles, cradles, and her baby dolls. She loved playing house more than anything. That afternoon, Tyler waited for my son to leave the room. He unplugged the security camera with a speaker and a microphone, and he blocked the door with the TV. He asked my daughter if she wanted to play house. Of course, she agreed. But what she didn't agree to was having her pants pulled down, being pinned to the floor, and being raped by her 13-year-old cousin. She made her disclosure to me on December 22nd, 2018. But it would take another year before she would play with her baby dolls again. It took almost 2 months for Tyler to be arrested after her disclosure. We had to take a different route to school every day because if she saw Tyler, all the color would drain out of her face and she wouldn't talk the rest of the day. When I got the call on February 12th, 2019, from investigator Kenny Brock with the Washington County Sheriff's Office, that Tyler had been picked up at school, had confessed to raping my daughter, and was sitting in custody at the Washington County Jail, a wave of relief passed over me. That relief would be short-lived. Because of the damage to the juvenile facility in Panama City from Hurricane Michael, Tyler would be transported to Crestview, where he would appear before Judge Brown in Okaloosa County the next day for his first appearance. And even though Tyler scored for pretrial detention, DJJ recommended it, the state attorney's office asked for it, and the public defender agreed to it. Judge Brown looked at Tyler and told him, "Son, I believe you did what they say you did, but your daddy is here today with you, so I'm going to let you go home." No one let us know about the first appearance. No one let us know that he was released that day. DJJ informed Tyler that he could go back to school with my children. Thankfully, I had the foresight to call the school principal the day of Tyler's arrest, and she assured me he would never come back to her school, and she kept her word. On Friday, February 15th, I checked the mail. In it was a letter from DJJ notifying me of my daughter's rights as a victim of crime, and including a phone number for Tyler's probation officer. I called the officer immediately, and that was when I was informed, finally, that he had been released to his father's custody. The same father who was well aware that his son had been investigated in 2011 for child-on-child sexual abuse against another female family member. The same father who never warned us that his son had a prior history. The same father who never warned us that his son was already addicted to pornography at 13 years old. The same father who blamed my husband for not supervising his son. My daughter was absolutely devastated to learn that Tyler had been released after she'd been assured by everyone involved that he was in jail and would stay there until his trial. She had started trauma therapy almost immediately after her disclosure in December, and this would set her back weeks in therapy. Despite hiring an attorney for my daughter, despite intervention from the Marcy's Law for Florida Foundation, Judge Lucas Taylor refused to put Tyler back in detention. After nearly 2 years of legal involvement, Tyler was finally sentenced to a residential facility for juvenile sex offenders and was ordered to a detention facility to await a bed. He would spend a total of 3 months in a detention facility before being released to what amounted to a summer camp for juvenile predators. 3 months was all that my child was worth to Lucas Taylor. I stand before you today having walked this path before, knowing about the second chance that DCF gave Tyler in 2011 because of his age, knowing about the third and fourth chances that Judge Brown and Judge Taylor have given to Tyler, again because of his age, begging you not to give him any more chances. He will be 20 in November, and he has well established himself at this point as a predator. He knows exactly what he is doing, and he fully believes that he will get away with it. In January of this year, Judge Taylor released Tyler from supervision with no notice, no hearing. He didn't even serve a copy of the order on the state attorney's office. But even though Tyler's case involving my daughter might be legally over, it's not over for my daughter. She is devastated today because despite her bravery in coming forward, despite her bravery in telling her story, not only to authorities, but also publicly to support other survivors, Tyler has raped again. Had Judge Taylor acted appropriately and sent Tyler to a detention facility for the rest of his youth, there would be no third victim suffering today. My child is devastated today that yet another child's life has been turned upside down to satisfy Tyler's sexual perversions. She feels helpless and betrayed. I'm begging you today not to do this to another survivor. Although she has a legal right to be here today, you shouldn't have to be told by a rape victim that she wants her rapist in pretrial custody. She does. Tyler's proclivity for sexual violence is evident by the fact that he could not even go a year off of supervision without being arrested for yet another sexual battery on a minor. Tyler's proclivity for sexual violence was evident in the psychosexual evaluation conducted through the Department of Juvenile Justice. For a multitude of reasons, he was rated moderate to high risk to reoffend, and now he has. We found out yesterday that Tyler has been living less than 2 miles from our church, a sanctuary for my child, a place that was untouched by Tyler or his family, a place that offered her safety and comfort. But we have unknowingly been driving by him every Sunday morning. I'm begging you today to give my daughter the peace that she deserves. I'm begging you today to give the victim in the case the peace that they deserve. I am begging you today to hold Tyler in pretrial detention. It is time to stop being willing to sacrifice more children to this man. His family has proven themselves completely incapable and unwilling to adequately supervise Tyler. I'm asking you today not to trust them anymore. Tyler is now a grown man. It's time to put him away with other grown men who have made the same choices. His chosen attorney can come visit him in the jail just as easily as he can visit him at home. Pretrial detention does not violate any of his rights, but will protect other children in the community from harm during the course of this case. In full candor, I am the county attorney for the county jail where Tyler sits this morning. If that brings you any level of discomfort, I would ask that you not release Tyler, but instead move him to a facility in another county. Thank you.
Thank you, Ms. Jordan. Does Mr. Tadlock's family, anybody want to be heard? Either do or you don't. It's up to you. Okay. All right. So, Mr. McDaniel, on the motion for pretrial detention, I read the motion this morning. I went and read the rule. Ms. Jeffcoat's here on that case, and it's not my job to rule on it. I do have a question or a concern. That rule is a little bit confusing, Ms. Jeffcoat.
It is, Your Honor.
In one place, it mentions capital life and first degree felonies, and in one place, it just mentions dangerous crimes. So he's accused of dangerous crimes, but he's not accused of a first degree or higher. Is that right?
That is correct, Your Honor. The charges that he is currently charged with are all second-degree felonies. The state is proceeding under the dangerous charge rule. We believe that the state will be able to show that he poses a threat to the community based on his prior history of similar acts. And also there is another subsection that I don't have enough information on yet to include in my motion, but I believe the allegation dates are after he was released from probation. But I spoke with the victim's guardian yesterday, and she indicated that some of his, he definitely befriended the child and maybe started some of the grooming behaviors while he was still under the supervision of DJJ, which gives the state huge concerns about his ability to not reoffend while on a court-ordered supervision or pretrial release of any sort.
Okay, and according to the complaint, he's admitted to the latest allegations,
He did, Your Honor. He made
Consisting of
admissions to
three
both.
second-degree felonies.
Correct, Your Honor.
Okay. Anything else, Ms. Jeffcoat?
Nothing further at this
All
time.
right, Mr. McDaniel, anything?
Nothing, Your Honor.
Mr. Tadlock, I'm going to find the state's filed a motion for pretrial detention. There's certainly a basis to believe that you may be fall under that statute. You may be a danger to our community. So I'm going to hold you with no bond until Judge Garcia can have the hearing. Under Florida law, that hearing takes place within 5 days. And we got an email from Judge Garcia. I believe that hearing is going to take place the latter part of next week, Wednesday or Thursday, perhaps.
Yes, Your Honor.
So I'm going to ask the state and defense to coordinate that hearing. So, Mr. Tadlock, you'll be in front of Judge Garcia next week for a full hearing on a motion for pretrial detention, but there's certainly enough evidence for me to make a preliminary decision that you need to be held with no bond due to the danger to the community statute. Mr. Tadlock, do you have any questions?
No, Your Honor.
All right, sir. Wish you the best. Thank you, Ms. Jordan. Thank you, family members, for coming.
And Your Honor, for Mr. McDaniel's benefit, just so he knows, I will go ahead and get a copy of the CPT today and get an information filed so that the PD's office can be appointed and maybe Mr. Blunt or one of the other assistant PDs can handle that hearing.
All right. Thank you, Mr. Jeffcoat. All right. The next case that has friends or family here is Alexandra Goss. Ms. Goss, come on up.
And Your Honor, I guess for Mr. Tadlock, since an information is going to be filed, his court date is going to be September 2nd.
Thank you. And Ms. Jordan, Ms. Jeffcoat, Ms. Jordan. So starting today, coincidentally, Judge Garcia is asking, and we've agreed to give all felony cases an arraignment docket date. And the reason for that is just as a tracking mechanism because of the recent changes in the Florida speedy trial rule and the 40-day or 60-day rule. So I need Mr. Tadlock back, Mr. McDaniel.
Yes, Your Honor.
And that this is the very first case we've done this on, so I make sure to do it. Thank you, Mr. Mitchell. I'd already forgotten. We talked about it 15 minutes ago and I already forgot.
It's Friday. We're thinking about that right there.
Mr. Tadlock, come on back up. Mr. Tadlock, we're going to go ahead and give you a court day. Now, if the state's filed information by that point, this will be an arraignment day. If the state has not filed information by that point, it'll be kind of a case management docket, and Judge Garcia will see where things stand with the state attorney's office. And that's all based upon your arrest date. I'm going to ask the jail to give you a notice to be in court September 2nd at 8:30 a.m. That'll be your next court date. And you will, you'll see why, if the state's charged you, it'll be an arraignment date. If the state has not charged you at that point, it'll be a status date to see where things stand, September 2nd. So you're going to have the hearing within 5 days that I mentioned earlier. In addition to that, if you're still in jail or you're out of jail, it doesn't matter. Either way, you're going to be in court September 2nd at 8:30. You will not get a notice in the mail. So if at some point you are on bond, it's your responsibility to be there. Any questions, Mr. Tadlock?
No, Your Honor.
All right, sir. Have a good day. Thank you, Mr. Mitchell, for reminding me of that. And then we'll go to Ms. Goss. Ms. Goss, good morning. Ms. Goss, you're here for first appearance accused of 1 count of child abuse. Ms. Goss, I read the complaint. I believe I was the judge that signed the warrant in this case, and I read the complaint filed by law enforcement, ma'am. There is probable cause in the complaint. When I got your criminal history this morning, Ms. Goss, it appears to me that you have no prior criminal history. Is that accurate, ma'am?
Yes, sir.
Ms. Goss, your boyfriend is in the courtroom on your behalf, ma'am. Just want you to know he's here this morning. And let me see if the attorneys have any additional information, ma'am, before I address your bond or your release status. Mr. McDaniel, anything on behalf of Ms. Goss?
Just what I texted you, nothing else.
And that was that she had no prior history and
Asking for a cash bond.
she requesting a cash bond. And Mr. Mitchell, what's the state's thoughts?
I have no objection if she wants to get a cash bond.
Okay. So Ms. Goss, Ma'am, what I'm going to do is let you pick between a cash bond. I'm going to offer you a conditional release because of your no prior history and because of the allegations that Mr. Mitchell, I don't know that there's a right way to do this kind of investigation, but I have never seen a law enforcement officer let a parent question a child victim instead of questioning themselves. So in this case, the deputy says he let the child's father question him about what happened in the presence of the deputy. And I'm not sure that's appropriate. I know that the law enforcement they try not to make the child go through the statement more times than necessary, but normally they'll do a CPT interview or something like that. So that causes me some concern. Just making you aware of it so you can talk to the law enforcement agency about it. That may be their normal practice. That may be a reason they did that. But it seems to me letting another divorced parent question the child, tell the officer what happened, may not be the best way to elicit information. So I'm taking that into account, that the information, the allegations are arriving from a former spouse questioning the child in the presence of the officer. So it is what it is. So, Mr. McDaniel, I did notice that. I wanted Mr. Mitchell to make sure he was aware of that. Mr. McDaniel, anything else on behalf of Ms. Goss?
Nothing else.
Mr. McDaniel, Mr. Mitchell, I'm sorry.
Nothing.
So you can pick between a cash bond and a conditional release. I am going to offer you a conditional release, Ms. Goss. If you want to accept the conditional release, you will have a condition of no contact. Actually, we're going to talk about the no contact. I'm not going to do a straight no contact. I would never do that in a case like this. We're going to talk about the contact with the child in just a minute. If you want to post a cash bond, I would set you the standard cash bond for a third-degree felony, which is $500 cash. So we'll talk about the no contact in a minute. Would you prefer the cash bond or would you prefer the conditional release?
I'll do the cash bond.
Okay, so what that means, sir, is she's chosen the $500 cash bond. The advantage to a cash bond is this. If the case is dismissed, the cash is returned to whoever posted it. If it's not dismissed and she's ordered to pay court cost fines, the money goes towards court costs and fines. So in that sense, it may be better in some cases than a surety bond going through a bondsman. So her bond is $500 cash. Next, I've got to talk about no contact with the alleged victim. This is a 7-year-old. So what I need to know, Mr. McDaniel or Ms. Goss, is the Department of Children and Families involved?
Yes, Your Honor.
Okay, so were they involved before yesterday or were they involved?
Yes, sir.
Okay, so are there any type of restrictions they put on contact at least before yesterday? Was there any kind of case plan involved or anything? Okay.
No, sir,
So
not in regards to me.
What I want to do as far as the contact is I'm going to, as part of your bond, you're going to have a condition of contact in compliance with Department of Children and Families recommendations. So I have no idea what their recommendations will be, but they're much more equipped to deal with that. They know the whole case history, family history, and I don't. So I'm not going to do no contact. I'm going to put no contact unless it's authorized by DCF. So they may authorize in-person contact. They may authorize supervised contact. They may authorize no contact. But DCF's got authority to do that. And if you disagree with the contact that they have, then you've got to come back before myself or Judge Garcia to request more contact. So I'm going to say no contact unless it's approved by DCF in the manner and form that they prescribe. Ms. Goss, do you have any questions?
No, sir.
All right.
Jake, give some further information. DCF was involved because they were investigating the father. And, I took that into account as well when I'm looking at the father questioning the child and asked all the questions and stuff.
It was really unusual. There may be a special reason. I'm not being critical. There may be a reason they're doing that, but I've never seen it before. I've never seen an officer let especially an ex-spouse question the child, tell them what happened next. Never seen that before. Normally you get the parent out of the way and talk to the child in private.
Yeah, I don't know if he's watching, but if Captain Bassford doesn't know about this, I'll talk to him about that.
And he wasn't the officer. He's just a supervisor.
He's just the supervisor, yeah.
All right. So Ms. Goss, you will get to use the phone in just a few minutes, ma'am, but just know that your boyfriend's here. He knows the cash bond. Her question, if I was in her shoes, my question would be, are you going to be able to post the cash bond, sir? He said he's going to get the cash bond posted, ma'am, and you're going to be released. Just don't have any contact until DCF lets you know what the parameters are. Sir, do you have any questions?
No, sir, I don't.
All right. So Ms. Goss, I wish you the best, ma'am. And also I want to ask the jail to give you a notice. Similarly, your court date will be September 2nd at 8:30 a.m. If the state has filed formal information by then, that will be an arraignment date. If the state has not charged you yet, that'll be a status date for Judge Garcia to see what's going on in the case. Ms. Goss, any questions?
No, sir, that was it. Thank you.
Have a good day, ma'am.
You too. Thank you.
Next, we have one more case that has friends or family here, Mr. McDaniel, and that is Marcus Johnson.
Judge, I know we didn't go into this. I didn't think it was a big deal at the time, but they have.
Wait a sec, Mr. McDaniel. Her boyfriend has left the courtroom. Do we need him back in here?
No, no, sir.
She has more
James, they
than
don't
one
need
child.
I have.
Hang on.
Oh, I'm sorry.
She has more than one child with the father, and the father left with the other child as well. And she has custody of the child, I guess, and she's asking the court, is it going to be okay for her to get at least her other child?
There's no indication, there's no reason for me to believe the other child's in any danger. Mr. Mitchell, anything?
I'm in agreement with you, Your Honor.
There's no restrictions on contact with that child, okay? Thanks for clarifying. So her question was, does this affect her visitation or her custody of the other child? And the answer is no, it doesn't. Okay. Okay. Yes, sir. Mr. Johnson's next. Mr. Johnson, good morning. You're here for first appearance for one charge possession of firearm on school property. Your mother's in the courtroom and another gentleman is also here, a friend or family member. Mr. Johnson, I've read the complaint. In your case, there is probable cause. This is the allegation is you allegedly had a firearm in a bag on a school trip because of an issue you supposedly had with someone outside a different school. There's no allegation that you took the firearm to the school here in Jackson County, but allegedly you took it on a trip and you were on the bus and the bus was on school property. That's where the basis of the charge is. Mr. Johnson, the criminal history I've got shows no prior history. Is that accurate, sir?
Yes, sir. I've never been in trouble.
Perfect. In the pretrial release sheet, it says you're 19 and you're a Chipola College student. Is that right?
Yes, sir. I go to Chipola for welding.
I'm assuming that, so that means you're no longer a student in the Jackson County school system, correct? You're not dual enrolled or early admitted. You're through with high school, right?
Yes, sir. I got a diploma and stuff.
Okay, so we'll make sure you're through with high school. So you don't even have any need to go back on school property because you're no longer a student, correct?
Correct.
Okay, Mr. McDaniel, anything else on behalf of Mr. Johnson?
Your Honor, we just asked for, a cash bond or some kind of release option like that. The case was not incredibly strong. I mean, it's two witnesses that may be biased. I don't know. But I know that there was never no gun found. So, we just asked the court to take that into consideration.
Thank you. Mr. Mitchell, you may not, I'm not sure if the state attorney's office is involved in the review of this or not. This charge allegedly occurred in April and they asked for a warrant August 20th. 4.5 months later, and I signed the warrant the same day it was requested. So do you have any idea what happened between April and August? It makes me think no law enforcement wasn't too concerned about it because they've held on it 4 months, but there may be some underlying circumstances I'm not been made aware of.
It did come into our office as a review case. I will say that.
But set in the state attorney's office for some time being reviewed. Okay.
Yes, and Ms. Jeffcoat just basically didn't file an information or direct file on it. She just said she sent a review correspondence to the sheriff's office saying that it was determined that probable cause does exist, so they can proceed with getting the warrant out there.
Okay. So the reason that's important, or that's at least relevant, Mr. Johnson, is if law enforcement felt that you were a threat to the school or other students, it's most likely, knowing our law enforcement as I do, they would have sought a warrant or made an arrest immediately upon them becoming aware of it. That didn't happen in this case. That's just a factor among the many factors I have to consider for bond or release purposes. Mr. Mitchell, anything else from the state?
No, Your Honor.
So what I'm going to do is let you pick between a bond and a conditional release. I normally wouldn't offer a conditional release for this charge based upon these circumstances with your prior history or lack of prior history and a 4-month delay for some unknown reason. I feel like I don't have any real reason to believe you're a current threat to our school system. So I'm gonna let you
Yes,
pick
sir.
between that bond and conditional release. If you want to post the bond, your attorney's requested the cash bond. Mr. Mitchell, no objection to a cash bond?
No objection.
If you want to post the bond, your bond's gonna be $500 cash. That's a normal cash bond I would set for a third-degree felony. If you want to accept the conditional release, I'm going to offer you a conditional release. You will have a condition not to go on any property of the Jackson County School District. Now, just to be clear, that has nothing to do with Chipola College. Not
Yes,
trying to
sir.
keep you away from college classes at all. Just want to keep you away from Jackson County School District while this case is pending. That means you can't go to any ball games on their property, anything like that. While this case is pending, we got to get all this sorted out. Do you
Yes,
have
sir.
any questions about your choice between the bond and the conditional release?
No, sir, I wanted the cash bond.
All right, and to the family, do y'all have any questions about that, ma'am? Ma'am, do you have any questions? Yes, ma'am. I want him to be able to hear you. So if you'll come on up here, I want your son to be able to hear your question. Your mom has a question, Mr. Johnson. Yes, ma'am.
Yes,
I
sir.
don't know if you understand what they're saying. He said you can do the conditional release. If you do the conditional release, you won't have to pay any money, but there'll be rules, and stipulations where you're not allowed to go to the school, which you know that because you've already graduated. And
Yes, ma'am.
am I correct?
Yeah,
about that?
the other rules on the conditional release are you'll be under supervision with a conditional release officer reporting to him or her, it's a him in this case, once a week by phone. You could be drug tested. You can't possess or consume alcoholic beverages at all. So, Mr. Johnson, the conditional release is usually quite a bit cheaper, but there's a cost supervision of $30 a month. The difference is, as your mother implied, and as Mr. McDaniel's probably already told you, there are many more rules to follow on a conditional release than a cash bond. The difference is you're definitely going to get out on the conditional release if you choose that this morning. If you choose the cash bond, you only get out when the cash bond is posted. Any questions about any of that?
And the money will come back, the $500 will come back to you if the case was dismissed, and the $500 will go toward court fees. So he advised me earlier he wanted the cash bond, but if he wants to change it, would you rather have cash bond or conditional release?
Why don't we do this? Why don't you talk to your mother after first appearance and let the jail know which one you want to choose, okay? So you
Yes,
get to use
sir.
the phone in a few minutes, contact your mother. You have her number, right?
Yes, sir, I know about her.
Talk to your mother, and then let the jail know if you want to accept the conditional release. If he accepts the conditional release, he gets brought to the courthouse, meets with Mr. Ham, then he'll be released after Mr. Ham goes over the release with him. If he chooses the cash bond after talking with you, he's not released until he posts the cash bond. Either way, can't go on any school property,
Yes,
okay?
Yes, sir.
Your Honor, what about possession of firearms in this situation? I know it's not exactly the typical firearm offense in this situation, but I just wanted to bring that to your attention.
Mr. Johnson, how old are you?
19, sir.
I'm
So
supposed
he
to have a
legally
handgun anyway.
he can't legally possess a handgun. That's easy. He can legally possess long guns. Do you own any long guns? By long guns, I mean rifles or shotguns?
I don't own no guns at all, sir.
Okay, so Mr. McDaniel, you want to be heard on that request from Mr. Mitchell?
I don't think it's an issue, so I don't think
Okay,
so.
I'm
All
gonna,
right.
I'm gonna add a condition to the bond or release, whichever he chooses, not to possess any firearms. Okay.
Yes, sir.
Yes, sir, question.
I'm Marcus' grandfather.
Yes, sir.
And,
Mr. Harvey, he might not be able to hear you. I want to make sure he can hear you, okay? Mr. Granville Harvey, your grandfather was the other gentleman I told you was in the courtroom, and Mr. Harvey has a question. Yes, sir.
Yes, sir.
Yes, I'm his grandfather, and we'll just go ahead on it. I think we should go ahead on just do the cash bond.
It does have fewer rules to follow. That's why Mr. McDaniel advises people of the option. So your grandfather says if you choose the cash bond, they are going to go ahead and be able to post that. It does have fewer rules to follow. Is that what you want to do?
Yes, sir.
Okay, so it's a $500 cash bond. It's posted at the jail, and as soon as it's posted, he'll be released.
Okay.
Thank you,
Yes, sir.
Harvey.
All right, thank you.
All right, lastly, I'm going to ask the jail to give you a notice for your court date. Your
Yes,
court
sir.
date will be the same as the other cases today. That'll be September 2nd. They're going to give you a written notice, Mr. Johnson. Mr. Johnson, that written notice they put in your hand will be the only notice you get. You will not get a notice in the mail. So make sure you show up September 2nd at 8:30 a.m. Any questions?
Yes, sir. No, sir. No, sir. No.
Have a good
question.
day, sir.
Yes, sir, Your Honor.
Mr. McDaniel takes care of the cases that we had friends or family here for us. We're going to need to go through a couple more cases we have on our docket. Janice Johnson is the next case.
Just to update all of you guys, we're going to continue to ride with Judge Glazer for a while. It's actually a fairly quiet morning out in the various courts that we monitor. I've got my eyes out, but we'll stay free. We'll stay here for a while.
Yes, I'm going to arraign you this morning and get you a lawyer appointed if that's what you're asking for. Would you like to have an attorney appointed to represent you?
Yes.
I'm going to appoint the public defender's officer to represent you in this case. Please listen to Mr. McDaniel, and I'm going to see if you have any questions in just a moment.
Your Honor, we're going to enter plea of not guilty. Yes, to set this on the September 4th pretrial docket, and I advise her, Mr. Green, to come by and visit her prior to that hearing.
September 4th pretrial. Mr. Mitchell, anything?
No, Your Honor.
So Mr. Green will see you before that court date. Ms. Johnson, do you have any questions, ma'am?
No, sir.
All right, ma'am. Have a good day. Roberto Torres. Mr. Torres, good morning, sir. You're here because you've been accused of, actually, you were first appeared on a couple new charges, and one of the judges, myself or someone else, held you for Calhoun County to see if they were going to seek a violation of probation warrant. Mr. Torres, they have obtained a violation of probation warrant. There's a no bond warrant out of Calhoun County. So just be aware of that. You have the right to post bond here. If you do, you'll go to Calhoun County. If you don't post bond here, you'll resolve these charges first and then go to Calhoun County. Any questions?
That
Have a good day,
is
sir.
felony cases, or are you going to set them on the arraignment date docket?
Thank you. We'll go ahead and do that. Thank you, Mr. McDaniel. That's a great idea. I'm going to ask the jail to give you a notice on the felony cases for September 2nd at 8:30. We'll see where we stand on that day. If they've filed an information against you by then, that's a charging document. You'll get arraigned. If they haven't, it'll be a status conference date for Judge Garcia.
Do I have a attorney?
We have already seen Mr. Tadlock. We've already seen Ms. Goss. Ricky Stewart is next. Ms. Stewart, good morning. You're here because you've been accused of one count of driving while license suspended or revoked knowingly. Ma'am, I did read the complaint. There is probable cause. I've also looked at your criminal history, which showed several prior charges in another state, most of which were older cases, perhaps all of which are older cases. And Ms. Stewart, I'm pulling up your driving record now to refresh my memory because I've forgotten what the basis for the suspension was. I think it was pretty recent, though. Mr. McDaniel may have made a note.
It's insurance. She didn't provide her insurance to the DMV office.
But how recent was that? It was in the last few months, wasn't it?
June, I think it was June 2nd, if I recall, sometime in June.
It was pretty recent suspension. Okay.
No, it's totally different.
Remember I said,
So Ms. Stewart, are you employed, ma'am?
I'm employed in St. Augustine, but I was just about to move there.
So I've got the complaint has a Malone address. So do you live in Malone, Florida, or you live in St. Augustine?
I'm right now, I'm in the process of moving to St. Augustine, so I'm still in Malone.
I thought you said you're about to move here.
She was about to move
No,
to
she
St.
said
Augustine. That's what I heard.
she said she's got a job in St. Augustine. She's about to move there.
So when's the last time you had a job, ma'am?
It was just this March.
Okay, and where was that at?
That was at the Yates Deli
Where's that at? Is that in Malone?
in Malone. Yes, sir.
And Ms. Stewart, what about,
I just
so if you
fell
hadn't
on
had a
hard-
job since March, what's happening? How you provided for yourself, supported yourself since March with no job?
My friend that I live with in Malone has been helping me, and unfortunately, I fell a victim of crime there, and I was unable to drive my car.
Okay, let me see if the state or defense have any additional information. Actually, let's see. In the other state, Mr. Mitchell, Mr. McDaniel, I have an old driving suspended license, but that's in 92. And then there's one in Florida that's unknowingly. And then there's some marijuana charges that are old stuff. Gwinnett County, I'm going to assume that's probably Georgia. Most of her stuff is older. So Mr. Mitchell, what's the state's position?
Your Honor, I know originally the offer that was put forward was a 1-year probation sentence, but I think given the fact that the previous two one was about 30 plus years ago, and then the other one was a civil citation. I have no objection if we want to treat this as a second degree misdemeanor DWLSR and sentence her to 6 months probation with the court's approval.
Thank you. Mr. McDaniel, anything?
We're just asking for a cash bond right now, Your Honor.
Okay.
If the court agrees with it, or,
Sure. I don't have a problem with a cash bond or a conditional release due to this type of charge, ma'am. If you want to accept the conditional release, that's great. I've explained that to a couple of people earlier. If you have any questions, I'll try to answer them. If you'd like to post a cash bond's $250 for this charge. You have a condition not to drive a motor vehicle unless you have a valid license. That condition applies whether you choose the bond or the release. You want to choose the bond of $250 cash, or do you want to choose the conditional release, or do you have questions?
The bond, please, sir.
It's $250 cash bond. I'm going to ask the jail to give you a notice for your court date, but your court date will be different because it's a misdemeanor court date. That will be September 29th at 9 a.m. Please give her notice for that day, Corporal. You'll get to use the phone shortly, ma'am, to try to post the bond, okay?
Thank you.
Yes, ma'am. Have a good day. Marcus Johnson, we've already seen. The last case, I believe, is John Williams. Mr. Williams, good morning. Mr. Williams, Mr. McDaniel has added you on the docket to try to see if we can get your case resolved. The charge of driving while license suspended or revoked knowingly. Please listen to Mr. McDaniel, your attorney.
Your Honor, I spoke to Mr. Williams in case number 25435 CT. He's going to plead no contest to the charges listed. He signed his plea waiver form, waived his right to jury trial, and called witnesses. The understanding he'll be sentenced to 10 days in the county jail. We have credit for 10 days. There'll be a $400 fine, which if he does not get paid, will become a civil judgment, and that will suspend his license as well. And that will take care of this case this morning, Your Honor.
Thank you. Mr. Mitchell, is that agreeable with the state?
It is, Your Honor.
Mr. Williams, did you hear that agreement?
Yes.
Mr. Williams, do you have any questions about that agreement?
No.
And is that the plea you would like to enter?
Part of it.
I'm sorry?
So,
Ms. Goss, accept the bond or conditional release?
Bond, $500 cash bond
And contact was limited.
to DCF compliance rules.
Mr. Williams, any questions?
No, sir.
And is this a plea you would like to enter, Mr. Williams?
Yes, sir.
Mr. Williams, I'm going to accept your plea of no contest to the charge of driving while license suspended or revoked. Knowingly, I am going to withhold adjudication of guilt based upon your criminal history, sentence you to 10 days in jail. Mr. Williams, you've got credit for 10 days you've already served, so you've completed this sentence. I'm also going to order court costs and fines of $400. If you get that paid, great. If you don't, there'll be a civil judgment entered for that amount. Mr. Williams, as far as this case goes, you're going to be released. If you have no holds anywhere, you'll be released totally. They always do a warrants check, make sure there's nothing out there. I'm not aware of anything, but as far as I know, everything you have is over with, and certainly this case is over with. Any questions, sir?
No, sir.
All right, sir. Wish you the best.
And Your Honor, I think he was tentatively scheduled on the arraignment docket for Monday, so we can go ahead and take him off that docket.
Sounds good. Mr. Mitchell, anything else on the recording this morning or for first appearance purposes?
No, Your Honor.
Mr. McDaniel, anything from the public defender's office?
All right, folks, let's go to Miami-Dade, where we have a guest judge, Judge Balding Bearded Oldman, sitting in for Judge Glazer today.
I'll ask my office about the interpreter. Oh, there she is, I think.
Good morning, ma'am. Are you our Persian interpreter? If so, unmute, turn on your camera. Hey, we can't hear you.
Unmute.
Can you hear me now?
Yes.
Yes.
All right, perfect.
What's the name of the defendant? Right. She did. I got it right here. Is Hamid Rizet?
Yes. Yes.
That's him. Okay. Raise your right hand, Madam Interpreter.
Madam Interpreter, you swear that you will well and faithfully interpret from Persian to English, English to Persian to the best of your ability, and that you have such ability. If so, say I do.
Yes, I do.
Do we also have a detective who is present, who I believe wanted to address the court?
Hasan ببینن که اینجا یه بازرس هستش در حضور داره در کورت یا نه.
Detective, what? Raise your right hand, detective, please. Prompt testimony gives the truth, the whole truth, and nothing but the truth. You're muted.
Sorry about that. Yes,
Okay.
sir.
Okay. What do you want to tell me about this case, please?
راجع به این کیس شما براشون بگم.
He is a PhD student at FIU. To my understanding, he's fluent in English. I just wanted to give a little bit of background on that. But the reason why I'm here today is I was requesting hopefully a psych eval because
Hold on, ma'am, hold on. We need to get it translated. Unless, does your client, Madam PD, does your client understand English?
He speaks some English, Judge, but he prefers an interpreter for court proceedings.
I understand completely.
ایشون گفتن که شما دانشجوی PhD هستین در دانشگاه FIU و تا حدودی انگلیسیتون خیلی خوب هستش، ولی خب ترجیح میدین برای مکالمات دادگاه مترجم داشته باشین. دادگاه اینو پرسید. ولی خواستم برای شما از نظر روانی شما رو ارزیابی بکنم.
Detective, tell me about the nature of the threat and who was the threat made to.
خواستم ببینن اتهامی که به شما
Alleged threat, I should say.
Yes, sir.
وارده به شما چی هستش که این خانم بازرس براتون توضیح بده.
So the alleged threat was made to one of his professors or his preceptor for his PhD program, and it was done via email.
تهدیدی که انجام شده از طریق ایمیل بوده به یکی از استادای PhD تون.
The language utilized was something to the effect of I see you more as dead than you are alive, and I want to help you with this.
زبانی که استفاده شده در این ایمیل اینه که مرده شما از زنده‌تون بهتره و من میخوام اون رو ببینم.
And what's he getting his PhD in?
I believe
در چیه؟
engineering, correct?
مهندسی، درسته؟
Has there been any?
I'm sorry, I cannot hear him at all.
I don't think he say anything at this point.
Oh, okay, sorry.
Is there any trace that the government has on this gentleman?
میگن هیچ ردی دولت از ایشون داره؟
Detective?
That I know of, no, sir.
نه من نمیدونم.
And where is he a citizen of?
خانم وضعیت سیتیزنشیپ شما چیه؟
Anybody want to tell me that answer?
I believe it's Iran, sir.
فکر میکنم شما هنوز سیتیزنشیپ ایران رو دارین، شهروند ایرانی هست.
Okay. What's the state's request for bail?
خواستم ببینم وظیفه چه حکمی در این مورد داره.
$15,000 with a passport surrender.
میخوان $15,000 جریمه بدین و پاسپورتتون هم تحویل بدین.
I don't know if the detective has any other input. I know you were requesting the psych eval.
میگه گفتن که میدونم بازرس خواسته که اطلاع دیگه نداره و خواسته که از نظر روانی شما ارزشیابی بشین.
Judge, I would ask that you find no probable cause.
که من میخوام ببینم هیچ شاهد قابل باوری در این مورد وجود داره.
There's no threat to kill or do bodily injury in any way.
که هیچ اتهامی یا هیچ تهدیدی از این که بخواد از نظر جسمانی صدمه‌ای برسونه ما نداریم.
At best, it looks like it's a suggestion that he could help her to be more alive or feel more alive.
و اینطوری که به نظر میاد اینجوری بوده که ایشون پیشنهاد کرده که من میخوام شما یه ذره بیشتر حالت زنده بودن داشته باشین.
Probable cause is found. Public defender is appointed. Bond is $25,000 plus house arrest, total lockdown.
میگن probable cause یا دلایل معتبر وجود داره، شاهدی که بتونن داشته باشن موجوده و وثیقه 25,000 دارن میذارن و محصور در منزل باشین.
Must surrender his passport.
پاسپورتتون هم باید تحویل بدین.
And I'm going to not order a psychological evaluation yet. Let it go to division, let the division attorneys speak with their client, and then they can make that request if they think it's appropriate.
میگه الان در حال حاضر ارزشیابی روانی اوردر نمیدم، میذارم خودتون برین توی قسمت خودتون و وکلا با هم دیگه صحبت کنین و اونجا تصمیم بگیرین چه چیزی behtar هست.
Judge, finding a probable cause is over defense objection. There's no indication of threat to kill or do bodily harm. With
So
regard
noted.
to the passport surrender, can he surrender his passport once he is out on house arrest?
Yes, ma'am.
میگه میتونه پاسپورتشو موقعی تحویل بده که از هاوس ارست، از محصور در خانه بودن بیرون بیاد و این شواهدی که ما داریم من خیلی متوجهش نمیدم.
How much time will he have to surrender the passport, Judge?
24 hours.
24 hours.
24 ساعت وقت دارین که پاسپورتتون تحویل بدین.
And Judge, I don't know if he can surrender a passport on a weekend to the clerk's office.
فکر نمی‌کنم بتونه آخر هفته ویکند پاسپورتش تحویل بده به دادگاه.
Would he be able to surrender it to the public defender's office on the next weekday?
میتونه اولین روز هفته آینده به دادستانی تحویل بده
No,
پاسپورتشو.
must surrender it to the clerk's office.
میگه نه، باید به همین آفیس کلرکس آفیس بده.
Does the clerk know whether or not they're available on the weekends in case he's released on a weekend?
میدون میگه کلرکار برای آخر هفته اویلیبل نیستن، در دسترس نیستن.
Detective, you wanted to say something?
Yes, sir. Can we do a mandatory stay away order from FIU?
Yes, I can.
دستور اجباری بدیم که از FIU شما به طور حتما دور باشین. گفت بله میتونیم.
Put that on the back of the A form, please.
Appreciate you, sir.
So were we able to find out if the clerk's office is available for passport surrender on Saturdays or Sundays?
No, they're not.
They're not? So if he were to be released over the weekend, then he would have to surrender the passport on the following Monday, correct?
میگه چون آخر هفته این اداره تعطیله و نمیتونید
Is that okay with you?
تحویل بدین، میشه دوشنبه بده.
Yes.
میگفتن بله دوشنبه امکانش هست.
بعد من میشه بهشون بگیدیم 25,000 تا رو من ندارم چجوری بدم؟ دانشجوام.
He's asking, I'm just a student. I cannot afford to pay $25,000.
You talk to your lawyer about that, sir. We're on the next case. Thank you.
شما با وکیلتون صحبت باید بکنید.
Thank you, Madam Interpreter. Appreciate it.
Thank you so much, Judge.
Terrell Cooper.
Thank you, Judge.
He bonded out, didn't he?
No.
Terrell Cooper?
He's got an AC.
Cooper is here. He has an AC, no bond.
Got it. I'm sorry. On 22-5859, he's out on bond. There's an AC has been issued, hold him no bond. And on the new case,
And then Judge, after this, we have the hospital here.
okay. Okay. Cooper, 10,000, count 1, 15,000, count 2, 5,000, count 3, and then 500, count 4. PC is found, public defenders appointed.
Judge, count 2 is a second-degree felony. Would you consider setting standard bond at 7,500?
No, I wouldn't. He's out, he's staying in anyway on the AC, so. Who's the hospital case?
Hospital case is Moses de Rosier.
What number is that, please?
49,
It would be on page
page 17.
Got it. Okay. Ms. Rozier, how are you feeling?
I'm good, man. How about yourself?
I'm good. I'm not in Ward D.
Nice to hear that.
Fleeing and eluding, weapon possession, reckless driving. PD is appointed, PC is found.
Judge Glazer found probable cause for all counts except for count 6 on F-25 18159.
Right, I'm sorry, all this was already done by Judge Glazer. What we need to do is set bonds.
Yes.
I have two A forms
Yes.
for two different cases.
Yes.
Okay. So let me do the first case that I started doing. She didn't do the PC finding on the first one, correct? State and PD?
She did probable cause finding on both cases.
Judge,
And on the one.
I'm sorry,
ended-
you're absolutely right. I'm sorry. My glasses are off. Yes, she did. Let me just set bonds.
Judge, one thing, in 5-9, I believe that she found probable cause for carjacking instead of the armed grand thefts. The state is requesting that the defendant be held without bond, and I'll provide a motion for pretrial detention this afternoon.
Okay. So let me do the first case I have, the first A form. 5,000, 2,500.
What case number is that, Judge?
I have no idea.
The 4-5,
The one that has the four
Top right
counts.
corner, top right corner.
I give you, oh, here, I'm sorry, 25, 18145, right.
3 counts, Your Honor.
because the reckless goes to the misdemeanor.
Right. 5,000, 2,500, 500 and 500.
Judge, on the traffic, that's in another division.
It's reckless drive, the traffic, I'm sorry, that should not be here. Strike count 4. Okay, just for the 3. Now, on the other case, which is 5-9. One through 4. $5,000.
Just be mindful that there's multiple counts of the first 2 charges.
I know, 5,000. 5,000. Count 5 is no bond. And count 6 and 7. 6 ROR, 7 ROR, 8, 11, 8 through 11. $5,000 plus 5,000 plus 5,000. Count 11 is 5,000.
Is it a misdemeanor?
Unlawful discharge. I apologize. You're absolutely correct. That's 500. Here we go. And the stay away orders also. Chris,
Is there a motion, Your Honor?
motion for what?
See, Judge, I'll provide the motion this afternoon for pretrial detention on the armed carjacking.
Okay, and there's a stay away order against Jessica Brown, Cairo Palacio, Junie Rico. And that's it. All righty.
So, Mr. Diz Rosier, currently you're being held no bond. You're gonna see your division judge on Monday, who's gonna set you for a special hearing within the next 5 days from then to determine whether or not you can get a bond on the case. Okay?
Okay.
All right, feel better.
This one again, for my life.
I don't know, I gave them to you and Courtney gave them back to me unsigned.
It's like,
Whatever.
It was one of those days. Okay.
Thank you.
Thank you, Chris. Renee Sanchez.
Bond out.
Joseph Anderson.
He's present, just got out of Ward D. I would ask for pretrial services.
Hey, Mr. Anderson. Ward D, PC found, reset, okay. Pretrial services alternate bond is 1,500. Thank you. Kevin Roming.
Hi, this is Mr. Roming. Good morning, sir. Good morning.
Good morning, sir. Possession of cocaine within 1,000 feet of a school, cannabis and trespass after warning. Stay away orders being entered. Guess the school address is 1114 Southwest First Street in Miami. Count 1 is 7,500. And count 2 and 3 are 500 each. PC is found, public offenders appointed. Thank you.
Judge, with regard to probable cause, are you finding probable cause for possession or possession with intent, Judge?
Possession with intent.
I would ask if you consider finding probable cause for just possession
No, ma'am.
for count 1.
No, ma'am. Thank you, though.
While I was glancing through other feeds, Ashley throws down with 10 gifted memberships. Thank you so much, Ashley. I really appreciate that. Congratulations to all of the new members. Let's stay in Florida, but let's go to Brantley Clark, where he's doing his felony docket.
It's intent to offer child hearsay, and I filed an objection to that.
All right. That's kind of counter to the law, isn't it? As the law reads now.
I filed an objection, Your Honor.
Well, what I'm going to do is I will take it under advisement. I will review. This is the CPTT. Yep. And I will take that under advisement.
Judge, I still think you need to find reliability and whether she testifies at trial.
Yes, I have to. I'm not making it a term. I'm taking your objection under advisement. I'm going to review this CPT tape, and then I am going to find whether it's reliable or not reliable. And then I will make it. And then at trial, if the child either testifies or is unable to testify, I'll make that determination whether the evidence comes in or not.
Yes, sir.
But I was just reserving on the motion, which I think I've seen the motion before today, and I think I've seen it 2 or 3 other times today also.
Yes, sir.
We set for trial in
October. If we could have that 9/19, I believe, is the trial management.
September 19th at 9 o'clock.
You want the 18th?
Yeah, September 18th. I'm sorry, September 18th at 9 o'clock.
Yes, sir.
All right, thank you.
And I'm giving him copies of the state's motion and my objection.
Very good.
Right. And Christopher Cox.
All right, let me try to catch up here. Michael, thank you for gifting a membership. Bailey, thank you for gifting 5. Barbara, thank you for gifting 1. Very much appreciated. I love it when you guys do this because it just helps hopefully expose more and more people to what we do here and bring them into the fold, at least with the morning show here, which I maintain, despite the fact that it's the one I run, so I should maintain it, but this is the best courtroom morning show out there, and the community itself proves it out. So thank you again, guys. I really appreciate it.
September night 18th at 9 o'clock, I'll reserve on the notice of intent to offer hearsay and also the objection to that after I hear the and after I review the statement and we determine at trial whether the child testifies or does not testify or is unable to testify.
Yes, sir.
Okay. Remember that week, I'm not available on the 8th of that week, Wednesday.
Investigator can show it to you again because he can see you before.
All right.
All right.
Thank you.
All right. And skipping ahead to Brayon Stevenson, so that we can take care of all these matters together. Your Honor, we're here today for trial management. The state has filed 2 motions. There's a motion of intent to offer child hearsay statements, to which I've filed an objection similar to the other 2 cases. I believe you need to, the child has to testify and you have to find that it's reliable.
Okay. I will take the notice of intent to offer hearsay under advisement. I also take the objection, the defendant's objection to the state's request under advisement, and I will review the statement, and then we'll make a determination at trial after the child either testifies or is made available to testify or is unable. We make a determination. I make a determination the child is unable to testify.
And Judge, the state had also filed a notice of intent to use similar fact evidence. It's basically the
hold on just a second, y'all. That's okay. Y'all be quiet. I can't hear. Go ahead.
I had originally overlooked this, but I think it's the complaining witness going to testify to more incidents than he's charged with. I'm preparing a motion in limine, so I just ask that you take it under advisement. My motion in limine will be self-speaking.
We could make that determination prior to jury selection, or we don't have to set another hearing date for that. Or do we need to? We can set it for the, this is set for trial September 29th.
Yes.
And we can set that for maybe the motion date for September 20th. And we'll do a motion and a trial management.
And the similar fact evidence is contained in the CPT.
Okay.
So that's her testimony that she would.
Well, I'll review that before the 20th, and then we'll make that determination September 20th, and also have a trial management September 20th.
September 20th.
Yeah, the motion day. I'm sorry, September 19th.
All right. And
I'm not going to be here that
at least you'll wait for my forthcoming motion in limine.
Yes.
Okay.
You want to submit that one?
Hmm?
You want to submit that motion?
It's in there.
Okay.
Yeah.
So real quick, while judges between contestants, Michael just put in the chat, it's been a great week for TCF and affiliated individuals. That it has. So anybody who is out there, if you are not currently subscribed to Michael Groff's YouTube channel, you need to go do that right now. Barbara, would you do me a favor and drop the link for Michael's channel in the chat, please? Michael does weather content. He has the perfect voice. He is a great personality. He has less subscribers than I do, and that is an absolute crime. My side quest in life is to get him more subs than I have. So if you're not already subbed to him, please do that as soon as Barbara drops the link in the chat. Thank you.
Okay. You call your first witness.
We'd call Miss Matos.
All right. If you'll raise your right hand.
Yes, ma'am.
All right. If you tell the judge your full name.
Adriana Marie Matos.
And how long have you lived in Bay County?
My whole life since I was 8 years old.
And do you have any family here?
My mother passed away a year ago. I have my little sister, and that's it.
Okay. And are they supportive of you and been in
Yes.
contact with me?
Yes, sir.
All right. Prior to your arrest, were you working?
I was working at Pancare Pharmacy.
Okay. And has your arrest caused a problem with that job?
Possibly, yes.
Okay. And my understanding is you work with Assistant State Attorney Ryan Phillips' wife. Is that correct?
Yes.
Okay. Do you have any prior record whatsoever?
No.
And would you agree with the judge and have no contact with the complaining witnesses in this case?
Absolutely.
Now, you're held without bond, so obviously you can't make a bond, but given your age and your lack of prior record and your job being kind of up in the air, is a significant bond going to continue to hold you?
Possibly.
Okay. Is there any amount of bond that you think that your family could make?
Probably like 25,000.
I don't have any other questions.
Quite any questions?
No, Your Honor.
Any other witnesses from the defense?
No, sir.
State have any witnesses?
No, Your Honor.
All right. Mr. White, I'll allow the state to make their argument. Mr. Meredith, I'll allow you to respond to that argument and make your own argument.
The state has spoken to the victim in this case, and it's my understanding that the defendant is the less egregious party of the two co-defendant or the two defendants from this incident. The state is fine with you setting a bond.
Meredith.
You are, knowing a little bit more about the playing field than Ms. Matos, I think a $10,000 bond would assure her attendance in court and keep the community safe. She's not a flight risk.
I'm going to grant the motion, set a $10,000 bond. You're to have absolutely no contact with the alleged victim in the case. You're not to have contact with and I'm assuming there is the co-defendant was charged, so you're not to have any reason to have contact with the co-defendant. She's shaking her head and that she does not need to have contact with the co-defendant. So I'm going to make that a special part of your bond, is that you have no contact with the co-defendant or any of the witnesses, and we'll need to set another court date. Let's set it for October 23rd. That's the in custody at 9 o'clock. If she bonds out, she'll get another court date. You just need to stay in contact with Mr. Meredith.
Yes, sir.
Okay. You going to make it?
Yeah.
Okay.
Thank you.
All right. And I don't see Mr. Overstreet here. Is someone going to cover for him? Okay. Mr. Moore? This is Kevin Moore, case 250933. He was arraigned last month, but Mr. Overstreet could not be here for a bond hearing, so we scheduled it today for Mr. Overstreet's calendar.
Okay. Is he going to be here today?
No, Your Honor, I'm covering for him.
Okay.
Oh, so we could have had it last month. Yeah. We'd like to call, right now, Mr. Moore is held without bond on 3 charges.
All right, you can call your first witness.
We'd call Mr. Moore. You swear to tell the truth?
Yes, ma'am.
Okay. All right, you can put your hand down. Tell the judge your full name.
Kevin Tyrone Moore Jr.,
And how old are you?
18,
And where do you live?
Dothan, Alabama.
All right, how long have you lived there?
Since I was 4.
And do you have family that lives there?
Yes, sir.
All right, who all lives there?
My grandma, most of my whole family.
All right. Now, I know some of them made the trip for the arraignment. Or do you have any family members in the audience today?
Yes, sir.
Okay. Who all is here?
My grandma, my sister, and my cousin.
Now, 18 years old, were you in school, working? What were you doing in Dothan?
In school.
High school or graduate?
High school.
In what grade?
10th.
What kind of grades were you making?
A's and B's.
All right. Have you ever had any prior charges?
Juvenile.
All right. Have you ever been charged prior to this as an adult?
No, sir.
Now, obviously, you don't have ties to Panama City, but you just live up the road in Dothan.
Yes, sir.
Right. And if the judge set a reasonable bond, would you guarantee that you would come to each and every court date?
Yes, sir.
Is there any amount of bond that your family could make in this matter? Or is you're held without bond, so you can't make a bond. But if there's a significant bond, is that still going to hold you?
No, sir.
And there are alleged victims in this case, and maybe some other people that you're around. Can you agree to stay away from them?
Yes, sir.
Don't have any other questions.
All right. Any other witnesses?
No, if those that are here for Mr. Moore could just stand so the judge can see who's here to support him.
Mr. Sullivan, any witness?
No, Your Honor.
I'll allow the state to make their argument. I'll allow Mr. Meredith to respond and make his own argument.
They would ask that the bond remain hold without bond. Not only were these extremely serious charges, the defendant doesn't have any ties in the community, was here during spring break. And this offense occurred in the middle of Pier Park at the height of spring break. Not only were the individuals that were shot at put at risk, but there were hundreds, if not thousands, of innocent individuals trying to enjoy their vacation put at risk by this extremely dangerous conduct.
Your Honor, Mr. Moore is presumed innocent of these charges. He is an 18-year-old going to high school. Although he doesn't live here, he's one of a lot of folks that come here to enjoy our beaches during spring break. He hasn't been proven guilty of anything. I believe he's entitled to a reasonable bond.
I'm going to grant the motion. I'm going to set $1 million bond on count 1, $1 million bond on count 2, $1 million bond on count 3. He's to have no contact with any alleged co-defendants, any alleged victims. He'll be, if he does make bond, he'll be subject to a 7 p.m., 7 a.m. curfew. Anything else?
We just need a pretrial date.
So when do you want to set that?
I'd rather do it October
23rd at 9 o'clock.
Do you make it?
Yes, sir.
Mr. Gunner, you ready?
Sir, good morning.
Good morning.
Your Honor, approaching is Gage Hudson in case 243007. This time he'll be prepared to enter a plea of no contest to count 1, burglary of an unoccupied dwelling, which is amended down with second-degree felony, punishable by 15 years DOC. Count 2, grand theft over 20,000. Another second-degree, punishable by 15 years. He'd be adjudicated guilty. He'd be sentenced to 66 months DOC. The sentences would run concurrent. He'd be assessed court costs and fines. He owe restitution in the amount of $32,000 to Jill H. Wills. He'd be awarded 341 days of jail credit. He provided DNA sample if requested. Stipulate to the facts of the PC affidavit. He'd agree to the imposition of minimum costs. He'd forfeit any seized items. He have no contact at all with any victims or co-defendants.
That's the agreement with the state?
Is, Your Honor. Your Honor, the victim is unable to make it today, but she did want me to relay the pain and the suffering this has caused her family for the sentimental value of the victims that were, or the items that were stolen from her home. she wanted me to put that on the record.
I will note that for the record.
Raise your hand, please. Solemnly swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God.
Yes, ma'am.
All right, Mr. Hudson, you can lower your hand and state your name.
Gage Hudson.
Mr. Hudson, you just heard the announcement of Mr. Gunner. Is that correct?
Yes, sir.
Is that your understanding of the agreement with the state?
Yes, sir.
Has anybody promised you anything different?
No, sir.
Are you under the influence of any drugs or alcohol this morning which would impair your ability to enter the agreement or
No, sir.
understand any of the terms and conditions of it?
No, sir.
I've been handed a plea waiver and consent form. There's the front page. On the second page is a signature of the defendant line. Is that yours?
Yes, sir.
You had to look at it first. Have you had a chance to read that agreement?
Yes, sir.
All right. Have you had a chance to go over your case with Mr. Gunner?
Yes, sir.
Have you had sufficient time to speak with Mr. Gunner about your case?
Yes, sir.
Are you satisfied with your lawyer's advice and counsel?
Absolutely.
You understand that by entering the plea, you're waiving your right to go to trial.
Yes, sir.
You're waiving your right to require the state prove the allegations against you.
Yes, sir.
You're waiving your right to have your attorney cross-examine the state's witnesses and contest their evidence.
Yes, sir.
You're waiving your right to present any defenses that you might have to the allegations.
Yes, sir.
You're waiving your right to subpoena your own witnesses to come to court and testify on your behalf.
Yes, sir.
You're waiving your right to testify to remain silent at the trial, which would be a decision you'd have to make.
Yes, sir.
You're waiving your right to appeal anything but an illegal sentence.
Yes, sir.
Are you doing this for your own free will?
Yes, sir.
Mr. Hudson, do you feel this plea is in your best interest?
Yes, sir.
Do you understand if you're not a citizen of the United States, you may be subjecting yourself to deportation proceedings by entering the plea?
Yes, sir.
Mr. Ferrer, Mr. Gunner's state or defense where any DNA evidence that exists which might tend to exonerate Mr. Hudson.
No, Your Honor.
No, sir.
Prima facie case.
Your Honor, the state is prepared to prove in case number 24, 3007 CF, that on or about September 9th, 2024, the defendant, Gage Hudson, did enter the unoccupied dwelling, the property of Jill Wills, with the intent to commit an offense therein. And once inside, did obtain jewelry in U.S. currency and other items of a value of more than $20,000.
I'll find there's a prima facie case. We'll find that Mr. Hudson's plea was freely and voluntarily made after consultation with his attorney. Is there any reason we can't go forward?
Yes, sir.
I'm going to accept it. Case number 24 CF 3007. He's adjudicated guilty of count 1, burglary of an unoccupied dwelling, and count 2, grand theft over $20,000. On each of those, he's sentenced to 66 months in the Florida Department of Corrections, given credit for 341 days. Time served on each count. They will run concurrent with each other. He's assessed fines and cost of $1,253. Those include discretionary cost of $2 of local law enforcement education, a $65 assessment of additional court cost, and a $700 discretionary fine. The fines and costs are reduced to a civil judgment. He's ordered to pay $32,000 in restitution to Jill H. Wills. That's also reduced to a civil judgment. If he's required to give a DNA sample, he must submit one. He'll forfeit any seized items. He's to have no contact with any victims or co-defendants. Have I left off anything?
No, Your Honor.
No, sir.
Mr. Hudson, you have 30 days to file your notice of appeal. If you wish to appeal your judgment sentence, if you'd like to have an attorney to represent you, you can't afford one. One may be appointed to represent you at no charge. Good luck to you, sir, and you step over and be fingerprinted.
Yes, sir.
Thank you, Your Honor.
I'll jump in until
Yes.
ready to come up.
Come on, Ms. Booth.
Alicia Coleman. This is with Mr. White. Yeah, to the judge.
There's one in the file.
Mm-mm. There's a new report. Hey, Miss Coleman. Come on, stand right here, hon. Your Honor, this is Miss Coleman. She's here before you in 251209. We've got a report from Dr. Rayleigh. He did an amended report this morning, which I believe Your Honor has a copy of. I have had a chance to read his report and review it, and I am in agreement.
Mr. White.
I've read the report and I'm in agreement as well, Your Honor.
No one's asking for another expert?
No, Your Honor.
No, Your Honor.
No objection to me accepting Dr. Rayleigh's report into evidence?
No objection.
No objection.
And I have a chance to review it. I am going to find that Ms. Coleman is incompetent to proceed, that the least restrictive measures available to restore the competency is commitment to the Florida State Hospital and Department of Children and Family, and I'm going to do that this time whenever I get the order. Good luck to you, ma'am.
We're gonna send you to the hospital and you'll come back when you're feeling better, okay? Okay, okay. Mr. Saline, are you ready?
Morning, Your Honor.
Good morning.
Judge, I have one that may be on Zoom. It was a Justice Administrative Commission motion. Attorney Charles Williams has spoken with me, as has his office. Apparently, Mr. Williams had filed a separate motion, but calendared it for, I believe, September. So he knows about today's hearing because his office was on our certificate of service, but I'm not sure if the court wants to move forward in light of the circumstances, or if the JAC would, object moving forward without Mr. Williams present. I could basically relay what Mr. Williams' position is, but I don't want to.
Does Mr. Williams want to delay it?
He did not tell me so, Your Honor, and I texted him a reminder again this morning. I did speak with him earlier this week, as well as Brittany, his assistant, and they never indicated a desire to delay the motion hearing. So I just didn't want to keep the JAC on the video all morning.
Your Honor, to explain the situation, it's relatively straightforward. What's happened here is Mr. Williams had the case for about 7 months. Then Mr. Saline took over after he was discharged and had the case for 5 months. And then basically Mr. Saline concluded the case. Both attorneys have submitted a bill for the full flat fee. We're not authorized to pay more than the flat fee without court approval. Essentially, what the court would need to do is find the case involved extraordinary and unusual effort, and then the court could double the flat fee and award each attorney the full flat fee. That would be within your discretion, but it's the attorney's burden to establish that that's a reasonable and appropriate under the circumstances. Here again, there's not a case where one attorney had the case for a couple of days or a week or two and then got discharged. Both attorneys had about 6 months in, and one actually took the case to final resolution. So we don't particularly have any particularized objection to both attorneys getting the full flat fee. It's just that the court has to make certain findings to allow that to happen.
Okay. Mr. Saline?
Yes, Your Honor, and I had spoken with Mr. Williams about splitting the fee, and Mr. Williams did not wish to participate in splitting a fee, so that was the reason why I had kept my billing at full amount. But if the court is so inclined to split between Mr. Williams and I don't personally have an objection to that. We did have the case go before you. In fact, I believe we even, were set for motion hearings. And
I think it was in front of, or was it reassigned to me?
Yes, I'm sorry, it went in front of Judge Gay, but it was reassigned to you because of you being
just for me for the
judge. Yes,
it's just assigned to me.
We did go through depositions, and we had depositions scheduled, but he ended up entering a plea April 8th in front of Judge Gay.
You were retained?
No, Your Honor, Mr. Williams stepped off of the case due to a conflict that arose after he had been representing Mr. Barnes for quite a while. I'm not sure if a witness became involved that he had previously represented. I'm not quite sure. I mean, I could testify to my involvement. I'm not sure what all Mr. Williams did. I don't believe any depositions were scheduled during that time period.
Mr. Williams looks like he was given notice of the hearing.
He was, Your Honor, on the certificate of service. Brittany spoke with me about it a couple of weeks ago, and I communicated with Mr. Williams this week as recently as this morning. I sent him a reminder that we would be here this morning. So, actually, I just got a text from Mr. Williams. I'm not going to be able to attend this morning, calendar conflict and a migraine. I'll just set my motion for a different hearing date. So I apologize for looking at the phone, Your Honor, but it just texted from Mr. Williams. So
let's reset it, and then JAC they've made their position clear. You don't have to come back unless you want to, and then I'll give Mr. Williams an opportunity. Go ahead.
Just to say, Your Honor, you do have the option to award Mr. Saline the full flat fee today without prejudice to Mr. Williams. If you're comfortable doing that, I mean, that way Mr. Saline doesn't have to come back.
I'll do that. I'll grant Mr. Selene's motion.
Yes, sir.
And I'll take, and then we'll set Mr. Williams' motion for, September 19th at 9 o'clock.
And thank you, sir. I appreciate that. And thank you, Your Honor. I appreciate that as well. I do have a motion hearing that's ready on Mr. McNair's case, if you wanted to take that up with Mr. Ferreira.
Yes.
Okay, come on down, Mr. McNair. Your Honor, this is the state of Florida versus John McNair. He is on your docket today in reference to a motion that had been filed. As Your Honor recalls, we had previously filed a motion asking for permission to depose one of the alleged child victims. This is a sex crime allegation. Naturally, the court had denied the motion, citing the proper authorities. We have since completed all of the depositions in the case, and unfortunately, we still do not have any definitive information as far as the child's position. The CPT interview is about 12 minutes long. I think Mr. Ferrer agrees with me on that. In the motion, I've offered the court if it would like to watch in camera the video, but my opinion is the child is playing and making loud screaming, screeching noises, but pretty much says nothing in the 12-minute CPT video that is supposedly said to the one or two people that the child allegedly disclosed this to. So it's our position that this is an example of a classic situation where the exception to the rule exists for us to be able to depose the older child. The younger one was too young to even speak at the time of the alleged offense. And not that the court is inclined, but I have no objection if the court wished to, view the CPT video in camera, as they say. But that's our concern, is we're in a position of going to trial without ever really knowing what the child is alleging, just relying on the word of an adult female or two claiming that the child made a disclosure. So that's the reason, Your Honor. I appreciate your time.
Mr. Ferrer?
The victim that they're trying to depose is 7 years old. I think there's a statutory presumption against having taken that deposition. The CPT is what it is, and that is the allegation. The allegations are all based upon the disclosures that were later made to people that have already been deposed by Mr. Saleen. The deposition of a child wouldn't serve really any purpose, and especially with a child 7 years old, victim of a sex kit.
You anticipate the child testifying at trial?
Yes.
I'm inclined to deny it, but I would like to do an in-camera
Yeah.
a review of the CPT. If you'll provide that in my office. Are we prepared to set it for trial now? Or are we?
Other than this, Your Honor, it's ready for trial. That would be the only
Why don't we set it
position I'm aware of.
for the 19th? Let me review that.
Yes, sir.
Yes, the 19th, and then.
September 19th for a
That's a
pretrial
motion day.
or trial minute. Okay.
We'll just call it for another, we'll just continue the motion until I hear that, and then, hopefully I can get you an order prior to that date, and then we'll set a trial after that date. Okay?
Yes. Thank you, Your Honor. I appreciate it.
All right, let's change things up a little bit. It's been a while since we've been here. Let's go to the Clayton County hallway where they're lining up for first appearances, and we'll spend a little time there.
Do you swear or affirm that the information you're about to give to this court, as well as any information you have provided on your application for court-appointed counsel, is true? Say, I do.
Jura usted y afirma que la información que está a punto de dar ante este tribunal, así como también la información suministrada en su solicitud para un abogado de oficio, es correcta y verdadera. Si así es, dígalo, juro.
All right. Thank you. And
Gracias.
deputies, if you guys will swing the camera around, I'll take our Spanish speaker.
Y'all can step inside.
All right. And good morning, sir. Can you tell me your name?
Buenos días, señor. ¿Podría usted decirme su nombre?
Rafael Ángel Hernández Gámez.
Rafael Ángel Hernández.
Gámez.
Okay.
Gambis.
All right. Give me just one moment to get your paperwork.
Deme un momento para buscar su documentación.
No, not yet. When you finish.
Okay, Mr. Hernandez, you have one charge.
Ok, señor Hernández, a usted se le imputa un cargo.
That's a violation of the Georgia Controlled Substances Act.
Y esto es de infringir las leyes antidrogas del estado de Georgia.
The bond on that charge will be $3,500.
Y la fianza por ese cargo va a ser de $3,500.
I also want you to stay away from 410 Old Dixie Way in Forest Park while out on bond.
Y yo también le voy a ordenar que se mantenga alejado de la 410 Old Dixie Way en Forest Park mientras usted esté en libertad bajo fianza.
Okay. Do you work at that location?
¿Trabaja usted en ese lugar?
Tengo mis familiares en esa, mis áreas.
I'm sorry, Your Honor. I have to ask Mr. Hernandez to repeat what he said. He was,
Yeah, that's fine.
no. Señor Hernández, ¿podría usted repetir lo que dijo? No le pude escuchar.
Y tengo mis familiares y hay veces ahí me dan ride para ir al trabajo en esa área.
Yeah, yes, I have some family members in that area, and sometimes they give me a ride to go to work.
All right, I'm on the clock.
But you do not work at the motel there, is that correct?
Pero usted no trabaja en el motel ahí, ¿es correcto?
No.
No.
Okay, I want you to stay away from that hotel for now.
Yo quiero que usted se mantenga alejado de ese hotel por ahora.
Your preliminary hearing will be September the 17th at 8:30 a.m.
Su audiencia preliminar está programada para el 17 de septiembre a las 8:30 de la mañana.
And give me one moment while I get your application for an attorney.
Y denme un momento para buscar su solicitud para un abogado.
Harry. Joseph. Midnight. Rose. Let's got any Rose on down. I got it. Time. Sorry, in there. Thompson. Walker. Williams.
Okay, Mr. Hernandez, are you currently employed?
Señor Hernández, ¿actualmente está usted empleado?
No.
No.
Going to assign an attorney to represent you on this charge?
Yo le voy a asignar un abogado para que lo represente en este cargo.
And that will take care of everything for us this morning. Do you have any questions?
Y eso sería todo por la mañana de hoy. ¿Tiene usted alguna pregunta?
Sí, ¿qué pasa si no pago? Si no tengo el dinero.
What happens if I don't pay, if I don't have the money?
Then you're not released from jail.
Entonces no lo pondría en libertad desde la cárcel.
And we would then have a hearing on September the 17th.
Entonces tendríamos una audiencia el día 17 de septiembre.
Y después de la audiencia, si no pago, o sea, si no tengo el dinero, ¿verdad?
And after the hearing, if I don't pay, I mean, if I don't have the money?
If your case, if we find probable cause at the hearing, we would send your case to Superior Court so that your next hearing is scheduled.
Si encontramos que hay suficiente motivo fundado en la audiencia, entonces su caso sería transferido al Tribunal Estatal para que usted tenga su próxima audiencia.
Okay. Thank you, sir.
Okay, gracias, señor.
And deputies, is that our only Spanish speaker?
Yes, sir. That's the only one. I think you can start.
Okay. All right. Thank you, Ms. Bermudez. Have a great weekend.
Yes, Your Honor. You as well.
All right. Thank you.
Your Honor.
Yes.
non-compliant, and I sent him back.
I didn't hear the first part of that.
Okay. Okay. One of the clients, and his name was, he was non-compliant up
Okay, the
here.
connection is
and
really
he,
breaking up a lot here. Tell me the name again. I heard non-compliant. Who was it?
His name is Malik Harris.
Malik Harris was non-compliant. Okay, so we will reset him for tomorrow's first appearances for
Yes, sir.
8/23.
I'll let the lieutenant know that you're resetting him for tomorrow.
Okay, all right, thank you.
Yeah.
Mm-hmm.
Yeah. Thank you.
All right, good morning, ma'am. Can you state your name for me? I'm sorry, the microphone's on mute there. You can say your name again.
Sophia Bailey.
Sophia Bailey. All right. So, Miss Bailey, you are charged with battery. That's a $3,500 bond, and you're charged with simple assault. That is a $1,500 bond. That gives you a total bond of $5,000. While out on bond, you will need to stay away from the alleged victim, Akolo Beverly.
Beverly, yeah.
It's Beverly. Okay.
I know
All
her.
right. So you need to stay away from her. You don't live at the same residence as her, right? Okay, so just don't have any contact with her for the time being. The preliminary hearing will be September the 16th at 8:30 a.m. And are you employed? Are you currently employed?
Oh, no, I'm not.
All right. I'm going to assign an attorney to represent you on these charges, and that will take care of everything for us this morning. Thank you, ma'am.
Where do I go?
I'm sorry?
Where do I go?
You talk to the deputies there.
Oh, okay. Thanks. Good night. Good night. Okay.
All right. Good morning, ma'am. Can you state your name for me?
Jasmine Casey Wiggins.
All right. And Miss Wiggins, you have got 3 charges here. So the first one is a felony violation of the Georgia Controlled Substances Act. That stems from May the 21st of this year. The Criminal Records Index indicates you were given 3 years of probation back in October in Superior Court. Because of that, we cannot give you a bond on felony charges, so I can't give you a bond on that one. The next 2 charges stem from the 19th of this month. That's providing a false name, address, or date of birth to law enforcement. That's a $1,500 bond, and you're also charged with tampering with evidence. That's a $2,000 bond. That preliminary hearing will be on September the 16th at 8:30 a.m. The let's see, let me get your attorney application out here.
But I can't for it. But who's removing things off all walls or something like that?
All right, hang on just a second. I got to get your application. I'll be right back.
Bailey, and this is Casey. It ain't having like hear you know, to get back. Excuse me, not having you. Where's my body came out? I know I said. What's his name? I'm McCoy. Whatever, something COS. That's that. Behind your lips.
Miss Wiggins, I'm still looking for your paperwork. Hang on just a second.
Okay. It might be under Casey because I have two last names.
Yeah, I think that may be what's going on. Here we go. I got it. Okay. And all right. I am going to appoint an attorney to represent you on this. And that'll take care of everything for this morning. All right. Thank you, ma'am.
Yes, if you don't have any questions. Next person.
All right. Give me just one moment, ma'am.
Next two come out on the other one. Yes.
All right. Good morning, ma'am. Can you state your name for me?
Good morning, my name is Drusilla Cofield.
All right, Ms. Cofield, you have one charge, that is aggravated assault with a deadly weapon. That is a felony. The bond is $15,000. The bond also includes a no contact and stay away provision with the alleged victim, Quarterius Trailer. Do you live in the same residence as your trailer?
No, I don't.
Okay. All right. So just stay away from him and have no contact for now. The preliminary hearing will be scheduled for September the 17th at 8:30 a.m. And give me just a minute to find your attorney application here. Okay. All right. And I am going to assign an attorney to represent you on this charge, and that will take care of everything this morning. Thank you, ma'am. All right. Good morning, ma'am. Can you state your name for me? Keep on my end. Can you say the
Romiko Howard.
Miss Howard? Okay. All right. So, Miss Howard, you have got 4 charges. I believe these are all misdemeanors. Yeah. There's a stop sign violation. That's a $500 bond. There's obstruction of a law enforcement officer being charged as a misdemeanor. That's a $1,000 bond. Open container violation. That's a $500 bond. And driving under the influence. That's going to be a $2,500 bond. So when I add all of these up, your total bond comes to $4,500. The preliminary hearing will be September the 16th at 8:30 a.m. And give me just a minute to get your attorney application.
That's what I'm for. That's too young. Yes. Right. You think it'd be good for your baby? You don't have a talk with her mama.
All right. And Based on your income level, you do not qualify as indigent under Georgia law, and so you don't qualify for a public defender. Okay. If you would like an attorney to represent you, you'll need to hire your own attorney. Okay.
Yes, I've been working on that.
Okay. All right. And that'll take care of everything today. Thank you, ma'am.
Well, he's between contestants. Bailey just put in the chat to Lady Jax. This is a test. What is your SSN? Just type it in the chat and a Nigerian prince will release $1 million in funds owed to you. So that reminded me that I never did an ad read today for Aura, but that's okay. We'll do an informal, very unapproved one right now. Protect yourselves from people like Bailey. Go to aura.com/TCF. Aura is absolutely excellent at protecting your data online. They will find data brokers or bad actors like our friend here and make sure that your information is removed from them, keep you safe online. They have all sorts of tools, including antivirus, credit monitoring, transaction monitoring, spam call protection, you name it. Aura.com/TCF. You get 14 days for free when you use that link. That is more than enough time for you to figure out exactly what they'll be able to do for you and decide whether or not it's the right thing for you to be protected from data brokers and people like Bailey. Aura.com/TCF. There is a link in the description.
And have no contact, and that means you can't be at the residence. So what you can do is schedule an appointment with the sheriff's office within the first 10 days of your release to get an appointment to go in. Now, that's a temporary bond condition. Your mother's not here today to tell me whether she wants contact, but she may. And so talk to your attorney about how to get that bond condition changed over time to maybe start allowing contact again or to allow you to go back home. Okay. Your attorney can help you with that. All right. The preliminary hearing will be September the 16th at 8:30 a.m. And let me get your attorney application out here.
Yeah. As opposed to that my name. You said to see me, but that was for another time. That was for another time.
Okay. And I am going to appoint an attorney to represent you on the charge. And that will take care of everything for us this morning. Okay. All right. Thank you, ma'am. All right. And good morning, ma'am. Can you state your name?
Excuse me.
I'm sorry. Can you say it again?
I couldn't hear you. Was breaking up.
I'm sorry. Can you state your name for me?
Amory Joseph.
Amory Joseph. All right. All right. So, Miss Joseph, you're charged with simple battery. Are you in school?
Yes, sir.
You go to Charles Drew High School?
Sir.
All right. What year are you there? Are you a senior?
Junior.
You're a junior?
Sir.
All right. Are your parents going to be able to bail you out?
Yes, sir. My mother.
Okay. I'd rather you be in school than in jail. That's where you're supposed to be, but so I'm going to set your bond at I'm going to set your bond at 500. Make that a little easier on her out. Now you're going to have to stay away from the alleged victim here and have no contact. Mayana Brown. Okay, so I don't want you having contact with her. All right. And we'll schedule your preliminary hearing for September the 16th. If you bond out, that hearing gets canceled and you'll get a notice in the mail from state court telling you when to come back in for your next hearing. Okay. They would schedule another hearing. And I am going to assign an attorney to represent on the charge. And that will take care of everything on your case today. Okay.
Okay.
Okay. Thank you, ma'am. Good luck to you.
That's fine. We were arguing and we were arguing on my father says I didn't leave.
All right. Excuse me just a moment, ma'am.
She the last person? Yeah. Walker's wife. Well, William.
All right. And good morning. Can you state your name for me?
My name is Shakia McKnight.
Miss McKnight. All right.
Oh.
Give me just a second here.
Your Honor,
Yes.
can I ask you a question?
I tell you what, let me go through my information first, and then I'll give you a chance to ask me a question, okay?
Yes, sir.
All right. So your 4 charges here, these are all misdemeanors. I'll tell you the bond amount, and then I'll give you the total in. So you're charged with providing a false name, address, or date of birth. That is a $1,500 bond. You're charged with public intoxication. That's a $1,000 bond. You're charged with loitering. That is a $1,000 bond. And you're charged with obstruction of an officer. That's a $1,000 bond. The bond will include a special condition that you're not to return to the subway on at Old Dixie Road and Old Dixie Way while out on bond. The preliminary hearing will be September the 16th. Excuse me just a moment. Okay. It will be September the 16th at 8:30 a.m. And let me get your attorney application out here. And I am going to assign an attorney to represent you. Okay, go ahead with your question.
Okay, so right now, I am a single mother of 9. And right now my friend, she one of my good friends, she's kind of watching my kids, one of my neighbors. And school just got back in and I just got back doing my classes with defects and things like that. So, I'm having to work through defects and do certain classes and stuff.
Okay.
And
Right.
I don't have the funds for this bond.
Okay. Well, the bond's going to be $4,500. Okay. You don't qualify for a signature bond. Okay.
Yes, sir.
All right. Thank you, ma'am.
How much did you say? Y'all write it down for me. 1,500. 1,500. 4,500. Heck, Miss. I'm thinking out in my. We're gonna write it down.
Good morning, Your
All
Honor.
right. Good morning. Can you state your name for me?
Rose DeMorse.
Okay, Miss DeMorse. Okay, you are charged with a false report of a crime. That's a misdemeanor. That bond is $2,000. While out on bond, you are to stay away from and have no contact with Michael Moffett. The preliminary hearing in your case will be scheduled for September the 16th at 8:30 a.m.
Yeah. Walker.
And I am going to assign an attorney to represent you, and that will take care of everything for us this morning. All right. Thank you, ma'am.
State something, Your Honor.
Yes, ma'am.
So with the officer, I've explained to him that I was engaged. He was he essayed me. And I told that to the officer. And I felt like the officer was being
Okay.
very.
We don't get into details here. We don't have the officer here to testify. That's your preliminary hearing. So that will be on September the 16th.
Well, may I ask for a reduction in my bond?
Yeah, it's going to be 2,000. Okay. But if you go through a bonding company, they may charge you 200 to 350, somewhere in there. Okay. All right. Thank you, ma'am.
10%.
Nintendo 50% of the 2,000. So you gotta pay the whole 2,000.
All right, good morning, ma'am. Can you state your name for me?
Jacqueline Rincon.
Miss Rincon, okay. All right, Ms. Rincon, you are charged with obstruction of a law enforcement officer. That's being charged as a misdemeanor. Your bond is going to be $2,000. The preliminary hearing.
Can you repeat that, please? You're glitching out.
I'm sorry, your bond is going to be 2,000, and your preliminary hearing will be September the 16th, and I am going to assign an attorney to represent you. And that'll take care of everything for us this morning. Thank you, ma'am.
I don't work. Is there any way that that could be reduced?
Your bond's going to be 2,000.
Okay.
Okay. All right. Thank you.
Thank you.
If you use this bond account, it's 10-15% of the 2,000.
All right. Good morning, ma'am. Can you state your name for me? I'm sorry. Say it again. Okay.
Back to your health unit.
Ms. Thompson, you have 3 charges. These are all misdemeanors. You're charged with improper lane change. That's $500. You're charged with driving under the influence. That is a $2,500 bond. And you're charged with possession of marijuana less than 1 ounce. That's a misdemeanor amount, and that's a $1,000 bond. So when I add all these together, your total bond comes to $4,000. The preliminary hearing will be September the 16th at 8:30 a.m. And let me get your attorney application here. Hang on just a minute here. All right. All right. And I am going to assign an attorney to represent you, and that will take care of everything this morning. Thank you, ma'am. Bond total is $4,000.
Thank you.
Okay. Okay. Thank you.
Oh, I want you to get her with the door.
Thompson. All right. Good morning, ma'am. Can you state your name for me?
Chandra Walker.
All right, Miss Walker. Give me just 1 second here.
Hey, Christian, what about a company?
All right. And Miss Walker, you charge that's criminal trespass. Set that bond at $1,000. That will include a special condition that you're not to return to Southern Regional Hospital unless you're seeking or receiving medical care while out on bond. The preliminary hearing will be September the 16th at 8:30 a.m. And let me get your attorney application here.
You say for me.
All right. And Ms. Walker, I am going to appoint an attorney to represent you, and that will take care of everything for us this morning. Thank you, ma'am.
Understand how I get a criminal trespassing from a hospital?
Talk to your attorney about it. They can kind of tell you what's alleged here. Okay.
Now, this facility, this area right now. Take me back to where I'm going. Now. Now, wait, I don't want to wait. Bring you right now. Now. Now, I'm telling you, I'm happy on this place. I'm telling you, I'm warning you. Everything. We all snatch it back. Oh my mother. It's on my mother. Take me back to where I'm going now. Now, I want to go now.
All right. And good morning, ma'am. Can you state your name for me?
Faith Wilkerson.
All right, Ms. Wilkerson, you have one charge. That's a violation of the Georgia Controlled Substances Act. That is a felony. That bond is $3,000. The preliminary hearing will be September the 17th at 8:30 a.m. And let me find your attorney application here. Okay, on your attorney application, it says refuse. Do you plan on hiring your own attorney?
Yeah.
You're going to be able to hire your own?
Yeah.
All right. So I'll indicate here that you're hiring your own attorney, and that'll take care of everything today. Thank you, ma'am. Good, good. Give me just a moment here.
I have it on my desk. Daily. It's on every right now. Oh, yes, okay. Hey, Steve.
All right, and good morning, ma'am. Can you state your name for me? I'm sorry, Veronica Williams, is that what you said?
Yes, sir.
Okay. All right. So, Miss Williams, you have one charge. That's criminal trespass. That bond is going to be $1,500. That will include a special condition that for the time being, you are to have no contact and stay away from Shanicia. I understand that you all live at the same residence. Is that right?
Can I ask you about that? Because I don't understand how that works. She's not on the lease or she doesn't contribute or anything like that. We haven't been there long. So that's why I'm confused.
So
Like that.
I'm gonna recommend you talk to your attorney about that. Okay.
Okay.
All right. They can tell you what's alleged and then what the law says about it. Okay.
Is it 100 or is it 150?
1,500 is the total bond. So a bond company might charge you $150 to $225, somewhere in there. Now, if Miss Cofield, if she is living there, then that means you can't be there. So you can't contact the sheriff's office 10 days of your release to get a date and time that you would be allowed to go in and get what personal items you need. You can also speak to your attorney about how to get that bond condition changed over time to maybe allow you to go back or to have contact with her. Okay.
Okay, I got a question because I don't contact them until 10 days afterwards. I'm released, right? To go back to get my items.
Yeah, you'll need to schedule that appointment with the sheriff's office to go in and get your items in that first 10 days. Okay. So you just schedule it as you're leaving is the best thing to do there. Okay. And then your preliminary hearing will be September the 16th at 8:30 a.m. And I am going to assign an attorney to represent you on this. And that will take care of everything for us this morning.
Thank
Okay.
you.
All right. Thank you, ma'am.
Where you from, what? Yeah, okay. That's fine. First one. That last girl.
All right. And can we raise the camera up just a little bit there?
What?
There we go. All right. Good morning, sir. Can you state your name for me?
Christopher Aldridge.
All right.
Can I say something, Judge? Real quick?
After I get done, let me tell you my part because I may answer your questions here, but when I get done, you can tell me what you want me to know. All right. You've got 3 charges. 2 of these charges are ones that only a superior court judge can set a bond on. That's hijacking a motor vehicle and armed robbery. You'll have a bond hearing scheduled in superior court later on those. Your 3rd charge is aggravated assault. I'm considered, but am denying bond on that. The hearing in your case here in magistrate court will be on September the 17th at 8:30 a.m. Let me get your application for an attorney out here. Okay, so on your attorney application, it says refuse. Do you plan on hiring your own attorney?
No, sir. I already have Christopher Tolles.
You're already represented? Okay. All right, I'm going to indicate that here.
Appointed him to me my last 2 court dates.
He's an appointed attorney on some, is it some other charges that you have pending?
No,
Because these are appointed by the charges.
no, sir. Mr. Mason, Avery Mason, I've seen him twice already. And
You've hired Mr. Tolles to represent you is what you're saying.
no, sir, I'm a conflict of interest case.
Okay, but is it on these? I don't think it would be on these charges because these are just coming through.
No, sir. I've been incarcerated for 3 years. These are 3-year-old charge. This is my third. This is my first appearance. This is the first time I've been to the county jail, though. That's what I was trying to explain.
Okay, you've been incarcerated already. All right. I got you. Okay.
Yeah,
Well, I'm just gonna, okay. You've already seen him. Okay. I'm just gonna indicate here that, you are approved for court-appointed counsel, and then if Mr. Tolles has already been appointed, then that's already taken care of. So, okay. And I told you, if you had, was there something else that you wanted to tell me?
Well, no, I was just going to ask when I was going in front of Mr. Mason for these 3 charges you just asked about, because yesterday they told me it was already bonded over to Superior Court.
Okay. So yeah, I don't know any scheduling on that, but you'll be hearing from Superior Court because they do their own schedule on it. The only thing is the preliminary hearing, and that's September the 17th. You may go to Superior Court before then. So okay. All right, but that'll take care of everything for us this morning. Thank you, sir.
Ladies and gentlemen, we've reached that point on a Friday where we go to our guilty pleasure. The one, the only. The place where the souls of the damned power the oppressive Cold War era lighting, where the echoes of the long dead and the past souls continue to linger, where people are just frightened and sometimes frightening. Let's go to Dungeon Court.
Things. And so, excuse me. So let's this would be your first offense. Under Ohio law, under a first offense, the maximum you can receive is 6 months in jail, $1,075 fine, and a 3-year license suspension. That's the most the court can impose. There is a minimum for this. Most charges don't have a minimum, but this is one of the ones that has a minimum. If you're found guilty, I can't give you less than 3 days in a treatment program, $375 fine, and a 6-month license suspension. That's the minimum. The state's alleging that you refuse to take tests. You're also charged with speeding, driving 71 in a 55 zone. That's not jailable. Maximum penalty is $150 fine. And the last charge is not wearing a safety belt. That's a mandatory $30 fine if you're found guilty. Do you understand the 3 charges against you? Do you understand what I explained the defendant's rights were just a few minutes ago? Any questions before you enter a plea? What plea do you wish to enter?
Guilty, sir.
If you enter a guilty plea, you're admitting the charges are true. You waive your rights to have a trial. You waive your rights to have a lawyer and to make the state proof of these charges beyond a reasonable doubt. You understand that? Is that what you want to do? Okay. I'm going to read the report of the officer. They prepare a report to the court. I'm going to read that into the record. And then, after you hear that, if you want to make a statement or an explanation, you can. You're not required to. Okay, so this Trooper Bean was the arresting officer from the State Highway Patrol. And he says, August 20th at 11:01 p.m. I was patrolling US 52 near milepost 14, Perry Township. I was monitoring speed of vehicles. I observed several vehicles approaching me eastbound. One of the vehicles was in the left lane, and I estimated visually their speed to be 70 miles an hour. The zone we were in was 55 miles an hour. I checked the vehicle speed on the radar device and measured the vehicle speed at 71 miles an hour. As it continued to approach, I watched it change lanes and fall in behind a sports bike with blue lights in the right lane. The vehicle was a white Nissan pickup truck. Passed me by, and then I caught up with it. the truck was following the sports bike, turned right onto Grandview Avenue. The truck had a Ohio plate of KDD 4536. Activated my overhead lights to initiate a traffic stop. The vehicle pulled off to the right onto a private lot off County Road 1 near Grandview Avenue. I approached the vehicle from the driver's side, made contact with the driver and the occupant. It was Eric Hanshaw, gives the date of birth. He was not wearing a safety belt, and according to the reason for the stop, and he provided his driver's license, asking if he had registration. He replied, yes, sir. There was some slurred speech and open case of Bud Lights in front passenger floorboard. I could detect an odor of alcohol coming from the vehicle. His eyes were watery and bloodshot. He struggled to retrieve his phone, dropped it between the seats. He apologized for the speed violation. He said the person on the motorcycle was a friend and they were goofing around, and he shouldn't have been doing that. Asking him about alcohol, he admitted to drinking one beer. Asked him to step out of the vehicle, informed him I would ask him some things to make sure he was safe to drive. He exited the truck, walked me to the front of my patrol car, and he stated that his last drink was about 45 minutes before the stop. Asked him preliminary questions to make sure he understood how to perform standard field sobriety tests. He reported having procedures on his right eye to correct an issue. He reported his left eye had full vision. He stated he did not wear contact lenses or glasses. He was not taking any medications. He stated he was in good physical health overall and did not have any history of head injuries. Detected an odor of alcohol coming from his breath. During my pre-check of his eyes, I could see that his right eye was looking slightly off stimulus. I had not been checking for that. His pupils were equal in size. They tracked equally. There was no resting nystagmus. There were 6 validated clues of impairment, lack of smooth pursuit, sustained nystagmus, onset of nystagmus prior to 45 degrees. Mr. Hanshaw was swaying during the eye testing. Walk and turn test. He took several steps that were not heel to toe. He made his turn by pivoting both feet. Stepped off the line while walking back. I thought there was 3 clues of impairment during the walk and turn test. Also on the one-leg stand test, 3 clues. Put his foot down, swayed, used his arm to balance, and did not count by thousands. I gave him a portable breath test, and it showed a test score of 11 on the portable breath test. And he was placed under arrest for OVI, Mirandais. This case of beer was roughly half empty. The truck was secured at the scene, transported to the post. He had urinated on himself while in the cruiser. He elected not to provide a breath sample at the post. He was released to a friend at his residence. Okay. Any explanation or statement you want to make?
No, sir.
Okay. Are you working?
Yeah.
What do you do?
I'm an order filler at the Walmart distribution center. Been there for 14 years.
Okay. You still live in South Point?
Currently, yes.
Well, I can give on driving privileges, that's always something that people want to know. You did have proof of insurance, so you don't have a suspended license. So I can give you driving privileges in 2 different ways. I can give you limited driving privileges, which means I'll give you an order from me saying you're allowed to drive for work, community service. If there's some other emergent type driving, I can order that. And you just have to maintain your insurance.
Right.
I can give you unlimited driving privileges, but in order to do that, you have to place the blow and go device on your vehicle. And you have to make the arrangements to get that placed on there. And then you have to blow into it whenever you start the vehicle. And I think it's about $1,100 to have that placed on the vehicle. And that, you don't pay the court. Well, we don't have them. You have, there's a place in Portsmouth that you would have to make arrangements to get that. So what do you want? Do you want the unlimited or you want the limited driving privileges?
I did have a question about the limited, if I could do that. I have 2 kids. I need to get to school. Would I be able to do that?
How old are they?
9 and 6.
Well, when I was 9 and 6, I took the bus.
Yeah, well, we're living out of the school district right now.
Oh, where do they go to school?
Dawson Bryant.
Okay. Yeah, well, I won't say nobody takes the bus, but 70% of the kids now.
Yeah.
Mom or dad takes them to school. When I was way back, I'm old now, but there was one kid, Keith Zimmerman, and he was a big baby. His mom took him to school every day. He was the only one. Everybody else rode the bus. I mean, that's just how it was then. You rode the school bus.
Yeah.
Okay, I'll let you do it for childcare. So here's the thing.
Yes, sir.
You're going to have an order from me saying you're allowed to do childcare, employment, community service, and the dip school. You have to go to the dip school.
Okay.
Drive. So if you get stopped, you're going to have to do some explaining.
Right.
So the best thing to do,
Okay.
don't get stopped. How do you do that? Well, you don't drive 71 and a 55.
Absolutely.
You use your turn signal. You obey stop signs.
Yes, sir.
Don't give them a reason to stop you, then you don't have to explain why you're driving. If you get stopped in that 6 months, you're going to have to explain, because it's going to show up as a suspension.
Okay.
So you'll have to explain that you're lawfully driving.
Okay.
And the only trouble we've had is in Kentucky. From most West Virginia, Ohio, they're going to accept the order.
Mm-hmm.
And most of the places in Kentucky, but I think there's been a couple of courts over there that said, we don't care what that Ohio judge says, you're still suspended. Okay, so forewarned, you might want to stay out of Kentucky or get somebody to drive if you're going into Kentucky.
All right. Yes, sir.
Okay, so on the OVI, now, I'm going to hit you hard on the fine, because this has been my policy since I've been on the bench.
Mm-hmm.
If you refuse to take the test, I'll give you a $1,000 fine for refusing to take the test. Because driving is a privilege, and when you got your driver's license, you said, I'm going to cooperate and do whatever the laws require me to do, and you refuse to take a test. So I think you need to pay a $1,000 fine for refusing. So that'll be the fine. I'll order you to pay the court costs. You'll get a 6-month license suspension. It starts the date of the incident, so it'll run through February 16th of next year. I'm going to give you a 20-day jail sentence, but I'll suspend it on the condition that you do the other things I'm going to order you to do.
Okay.
5 days of community service, when we have a community service program here at the court.
Mm-hmm.
What's your work schedule? Is it Monday through Friday? Or?
Saturday through Monday.
Okay.
Night shift.
All right, well, then you can work any day right here at the court at 7:30, community service, but Sunday or a holiday. So you'll have plenty of opportunity to get your community service done without interfering with your job. So just get it done.
Okay.
You got to go to a 3-day school. So I either got to give you jail or make you go to a 3-day school. You'd rather go to the 3-day school, I'm assuming.
Absolutely.
Jail's not, it's a place to be avoided. So there's one here in Lawrence County, but you can go to any one that's approved by the state. There's some cheaper ones around the state than the one here. I think the one in Chillicothe is like $200 cheaper than the one here. So if you want to go there, fine. You just got to make sure they report it back to the court that you did complete it, or I got to make you do the jail time. And it's a weekend program, so you got to go there and stay for the weekend. Well, the one here is, I don't know, I'm sure some of the big cities have got going all the time, but here it's a weekend program.
Okay.
You can talk to your probation officer and give you the information about how to get that set up. Okay, 2 years of probation. it'll conclude once you finish your, whatever you've got to do, get this done, you won't have to report anymore. I'm going to give you a review hearing on February the 27th, so that's 6 months out. You should get it all done before then. If you do, you don't have to come back for the review hearing. If you were here earlier, that's what those people were here for, reviews. You got to keep coming back. The only way you could go to jail on this is if you don't do it or don't come to your review hearings, and then you automatically get a warrant. So this is not going to go away. Don't blow it off. And we have people will walk out and say, well, I forgot.
Right.
How can you had an OBI with a jail sentence? How can you forget? I don't understand that, but people tell me that. I forgot I was supposed to do that. Well, then you're going to go to jail. Okay, on the speeding, I'll give you $50 fine. And the seatbelt's a mandatory, $30 fine. Okay, you've got to meet, your probation officer's going to be Mr. Major. He's in his office. Go out in the lobby, make a left-hand turn, and it's on that side of the building. Go check in with him. He's going to, everything I give you, you're not required to remember. He's going to give you papers with it on it. And here's the other thing. People say, I forgot what I was supposed to do. That's not an excuse. I lost my paper. I didn't know what I was supposed to do. Well, guess what? You can call the court. There's clerks here. They'll answer. They can pull up your case. You have a smartphone, don't you? Everybody has a smartphone. You can go on the internet, type in Lawrence County Municipal Court. We have a webpage. You put your name in. Your case will come up. It tells you what you got to do and when you got to do it. When's your next hearing? There's no excuses, although people try to make them all the time, why they didn't do so. So if you forget, don't remember, check with the court. We got the information. It's not going away. It's going to be here. Any questions?
No, sir.
Okay, go see Mr. Major. After that, you're free to go.
All right. Thank you.
All right, well, we wait for the next soul to come forward to be thrown into the fire and destroyed. Carolyn, welcome to our little community here. You've been very active in the chat, and we appreciate that. Stick around here for a while. This is the best community on YouTube, bar none, and I'm not just saying that because I run it. It's because I believe it. These are good people. But I do have to chide you on something. Just like there is no crying in baseball, there is no apologizing in the TCF chat. So never say words like so sorry. We don't do that here. Just participate, have fun. We're a great group. We all get along. Incredibly different backgrounds and beliefs, but we all come together. So it's good to have you here. By the way, for you and all the other new members out there today, we're in Dungeon Court right now. We have actually, a couple months ago now, made a brochure for Dungeon Court that is absolutely sublime. But to get it, you have to reach out to us via the member email, and then we will send it to you. If you don't know what the member email is, just go watch any pre-show, and it is prominently displayed on the screen there. So be sure to get your copy. Let's go back to the dungeon.
A lawyer.
I will hire a lawyer.
Okay. Well, let me tell you, when I'm setting cases, you can tell me if you need more time.
Okay.
So probably the 15th of September or after I can set your hearing. Is that enough time for you to get a lawyer?
Yes.
Okay. So you're working?
Yes.
Do you prefer a Monday or Friday to come back?
Either one, yeah.
Okay, so we'll make it the 15th, that's a Monday.
Okay.
September the 15th is going to be your next hearing. It's going to be a pre-trial at 10 o'clock. I'm putting down you will hire an attorney to represent you. I'm entering a not guilty plea for you. I'm going to let you, did you post the bond or did you just get cited in?
As far as, I just got cited.
Okay, I'm going to let you sign a signature bond.
Okay.
That's what he's putting in front of you. So what that means is a signature bond is like you're being your own guarantee. You're saying, I promise to come to court. If I don't show up, I'll pay $1,000 as a penalty, plus you get a warrant.
Okay.
Now, I have to order, it's a fairly new thing now, I have to order you to go to the jail to get fingerprinted. You haven't been fingerprinted on this yet.
Okay.
So Mr. Cooper is going to bring you back a piece of paper that you'll take to the jail, give it to him, They'll fingerprint you. You won't have to stay there. They'll just fingerprint you and then you'll leave. But you have to do that before your next hearing, September the 15th. So be back here September the 15th at 10 o'clock, unless your lawyer tells you they've made arrangements for a different date and you come on the date they say. Because they can ask, they may be busy that day. So. Any questions, sir?
No, sir.
All right, September 15th, 10 o'clock is your next hearing.
State of Ohio versus Madeline Wine. Madeline Wine, case number TRC 252064 A and B.
And ma'am, are you Madeline Wang?
Yes, yes, Your Honor.
Ms. Wang is alleged that August the 19th at 12:35 a.m. in Perry Township, you were operating a vehicle at a speed of 96 in a 55 zone. That's a minor misdemeanor, maximum penalty $150 fine. The state's also alleged you were under the influence of alcohol or drugs at the time. So you're charged with operating a vehicle intoxicated. That's a first-degree misdemeanor. And it's alleged to be your first offense. So the maximum is 6 months in jail, $1,075 fine, 3-year license suspension. The minimum penalty, if you're found guilty, is 3 days in treatment, $375 fine, 6-month license suspension. And the state's alleging you refuse to take tests. Do you understand? Those are the 2 charges. Do you understand the 2 charges?
Yes, Your Honor.
Do you understand the rights you have as a defendant?
Yes, Your Honor.
Any questions before you enter a plea?
No, Your Honor.
What plea do you wish to enter?
Not guilty.
You want a lawyer appointed to represent you?
I will be hiring private counsel, Your Honor.
Okay. And again, I'm setting cases on the 15th of September or thereafter right now for pretrial. So is that enough time for you to get a lawyer, or do you want more time than that?
That's fine, Your Honor.
Okay. I'm going to set it then for September the 15th as a pretrial. That'll be at 10 a.m. that day. Entering a not guilty plea for you. And you can sign a signature bond of $1,000. Do you understand what that means? And again, I have to order you to go get fingerprinted at the jail in Ironton. You need to do that before your next hearing. So Mr. Cooper is going to bring you back a paper to take with you to the jail to get fingerprinted. Give that paper to the jailer, and they'll know what to do.
Yeah, don't leave, I'll bring it.
Yeah, don't wait till he brings that back to you. Be here on the 15th or whatever date your lawyer tells you, if they make a different date. Do you have any questions?
Yes, Your Honor, I do. I just wanted to clarify for the fingerprints, I'm able to get it done. I wouldn't have to do it today, is that correct?
No, but before the 15th.
Yes, Your Honor. Thank you.
Okay, and there is a license suspension in effect, you understand that?
Yes, sir. I wanted to ask that. Thank you for bringing that up. I wanted to clarify, since it is suspended, what would, I mean, I'm taking Ubers right now just to accommodate, but would the suspension still be in effect?
Yes, under Ohio law, if you refuse to take the test, an automatic license suspension goes into effect immediately for refusing to take the test. And that can last a year. Now, if you get convicted, that suspension overrides the refusal and would replace it. But, so even if you got acquitted, if there's proof that you refuse to take tests, you get a 1-year license suspension under Ohio law. And you're a West Virginia driver though, right? You have a West Virginia license?
No, Your Honor. My license is from Saipan. It's a U.S. territory.
Okay. Well, foreign licenses are generally honored in the United States, but whatever suspension is in effect, all the states have entered into what's called an interstate compact. So You get suspended in one state, you're suspended in all of them. So if somebody ran your license, it's going to come with your identification, it's going to come up as suspended, whether it's West Virginia or Ohio. So yeah, that goes into the Ohio BMV, and then they put it out, and it goes to all the states.
So stick with Ubers right now, Your Honor?
Or get somebody to drive you around. Those are your options, yeah.
Thank you, Your Honor.
Okay, September 15th, 10 o'clock is your next hearing.
Yes, sir.
State of Ohio versus Rodney Spears, case number CRA 2548. Rodney Spears.
Sir, are you Rodney Spears?
Yes, sir.
Mr. Spears, it's alleged that at Fayette Township on August the 4th, you knowingly obtained or were in possession of a controlled substance, and that was methamphetamine. Possession of which is a felony of the 5th degree. So that carries a maximum penalty of a year in jail, $2,500 fine. Do you understand this charge?
Yes, sir.
Do you have the money to hire a lawyer?
No.
Do you have a job?
Yes.
What do you do?
Contract work, contracting.
Yourself, or do you work for a company?
I work for a company.
Who do you work for?
Silverstein Contracting at Huntington.
Are you paid by the hour?
Yeah.
How much per hour?
14.
Are you working steadily, or is it seasonal, or what?
Steadily.
Okay. How many hours a week?
40 usually.
So I have to determine your gross annual income. So you're making about $29,000 a year gross, is that right?
Roughly.
Do you have anybody you're supporting?
Yeah, my girlfriend and daughter.
Okay, you got a kid?
Yeah.
Okay, you're eligible for court-appointed counsel then. I'll appoint Mr. Stratton to represent you, get him in the courtroom he is here. Mr. Stratton, this is Rodney Spears, he's got a
Yes,
felony
Mr.
five,
Spears.
Possession.
We're being recorded, so we'll talk about that in the hallway, but.
Will counsel approach?
Yes, Your Honor.
Laurel Jeffries here. Laurel Jeffries.
I am
Let's go. You want to recall this, Your Honor, and do
You
that?
want to talk with him, and then,
Yes, let me talk to him, and then we,
all right. We call this to consider bond.
did you want to do what? He posted bond, but did you want to do what was recommended there?
Well, if you want to talk to him, what's the state, there is a bond out, what's the state's position on bond for Mr. Spears?
We'd like to see him assessed for treatment, and depending on what the recommendation would be, we want him to comply with that in order to be able to stay out of jail.
All right, let me, recall.
State of Ohio versus Hannah Gooden, case number TRC 222509, A, B, C, and D.
All right, and ma'am, you are Hannah Gooden?
Yes.
It's alleged that you've had a warrant outstanding since November 13th of 2023 for failure to appear for a review hearing?
Yes, Your Honor.
Okay, so do you admit or deny you failed to appear?
I admit that I failed to appear, Your Honor. I just graduated drug court in Boyd County.
In what county?
In Boyd County.
Boyd County.
I'm trying to get my life back on track and get this behind me so I don't have this hanging over my head anymore and get things taken care of.
Okay. At one point in 2023, you were going to ODP.
Yes.
I have a report from them. Did you got some proof that you
This
were in
is
the
my,
report?
this was for my, my drug court.
Okay. I'm gonna take a look at that. This was on an OBI conviction from May of 2023. Okay. Can we get copies? We'll get copies of that put in your file. Okay, so let me look at your. So what you did pay your fines and court costs. You have community service left.
Yes,
there.
yes, Your Honor.
So what I'm going to do is I'll put you back on the review docket, and you'll come back periodically until you get your community service stuff. I'll accept what you have as proof that you completed your counseling. You were ordered to do that.
Am I able to do community service in Ashland? Is that something I'm able to do?
Well, you need to discuss it with your probation officer. If there's a legitimate charitable organization over there that they've approved, then I'll let you do it there. Are you working now?
Yes, I have a full-time job. I work at Cheddar's.
Does it matter if it's Mondays or Fridays?
Preferably a Friday if you have it available.
I'll set it for October the 10th. You get everything done, confirm that with probation, you don't have to come back. Okay, I withdraw the warrant that had been issued. So your next hearing is October the 10th at 9 a.m. And check in with Mr. Major about doing your community service in Ashland. His office to the left as you leave the court.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Francis Barrett, case number CRB 25515.
Yes,
Sir, you're Francis W. Barrett.
that's correct.
Mr. Barrett, it's alleged that at Rome Township on August the 20th, you knowingly caused Sean Patrick to believe you would cause serious physical harm to his person or property. The charge filed is aggravated menacing. It's a first-degree misdemeanor. Maximum penalty, 6 months in jail, $1,000 fine. Do you understand the charge, sir?
Yes,
Do you understand your rights?
yes, Your Honor.
How do you plead to this charge?
Not guilty,
Do you want to be considered for a court-appointed lawyer, or you want to hire your own lawyer?
appointed.
Are you working?
I'm retired.
Do you have a pension or income coming in?
No.
You have
Oh,
a-
it's Social Security.
Social Security is your only income?
Yes,
All right, I'll appoint Mr. Morford to represent you. Entering a not guilty plea.
that's correct.
He has posted a bond, so the bond is continued. Is there any kind of protection order sought here?
I'm sorry, Your Honor.
Is there a protection order sought?
Yes, Your Honor.
Is it a problem for you to stay away from Sean Patrick? Okay. You don't live together or anything like that?
No,
Okay. I'm going to order, just so there won't be any allegations of another incident happening, I'm going to order that you stay away from Mr. Patrick while this case is pending. Don't go around him, don't contact him, don't post anything about him on social media. Okay? So you will have that to sign. Mr. Morford can talk to you about what that means further. And I'm setting cases, Mr. Morford, September the 15th or thereafter. So what's your availability?
Going to have to be after the 15th. I have a jury trial presently scheduled in front of Judge Finley.
that's for the protection order.
The 19th be good with you, Judge?
Yes. September the 19th will be the next hearing. It'll be a pretrial at 10 o'clock.
Don't leave, you'll bring a copy of this.
And he's been fingerprinted, so don't need to order that. September the 19th, 10 o'clock is the next thing.
Thank you, Your Honor.
And with that, my friends, we've reached that point where we must call it a day. I hope you've had fun today. It's a weird day, though. More young people doing stupid things, a couple of heavy cases to start the day. But, you know, the generosity of the community swoops in to save the day. Appreciate all of you for that. And, yeah, good day, good week overall. We'll be back live on this channel tomorrow night, 8 p.m. Eastern, 5 p.m. Pacific for game night. So if you want to hang out with us for something that isn't court, join us there, 8 p.m. Eastern, 5 p.m. Pacific. And then we'll be back for court live Monday morning, 10 a.m. Eastern, 7 a.m. Pacific, a half an hour early for channel members. Obviously, we will continue to post videos throughout the weekend, as we always do as well. So lots going on for you. But in the meantime, go have yourselves a great weekend. Hope to see you tomorrow night. If not, we'll see you Monday. Take care. God bless.